The House Committee on the Judiciary will come to order without objection. The chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing titled Silenced: How Forced Arbitration Keeps Victims of Sexual Violence and Sexual Harassment in the Shadows. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I would also remind members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in closed space, such as committee hearings, except when you are recognized to speak. I now recognize myself for an opening statement. Arbitration was originally developed as an alternative to the court system for parties of relatively equal bargaining power to enter into voluntarily. In recent decades, however, forced arbitration, which lacks many of the fundamental due process and transparency safeguards present in the courts, has worked its way into nearly every aspect of our lives, largely in the form of take-it-or-leave-it contracts between very large companies and individual consumers. The sum total of this trend is that forced arbitration clauses have rendered our court system inaccessible to far too many. Nowhere is that trend more apparent or problematic than in the workplace. It's projected that by 2024, 80% of private sector workers will be forced to sign an arbitration clause when accepting employment, a full 80% of our fellow citizens. And consider that over the past 5 years, employers prevailed over their employees in 98.1% of these arbitration cases. Somewhere in the paper these workers were required to sign, they bound themselves to a system in which they are nearly guaranteed to fail. They foreclosed the possibility of ever having their day in court, and in nearly all of these instances, they even gave up the right ever to talk about their experience. Excuse me. Now, it is easy to quantify the percentage of workers who give up their right to a trial by jury in order to get a job. We can count the number of individuals who have no idea what they have given away until it is too late. But it is difficult to fathom the true human toll of forced arbitration, stories that cannot be distilled down to a number or a statistic. That's why we're here today, to step back from the statistics and talk about a system that is fundamentally unjust. 4 of our witnesses today are survivors of sexual harassment and sexual assault. We are here to listen to their stories, and because they were forced into arbitration agreements as a condition of their employment, this is the first time many of these stories will be told in public. By forcing these women into silence, by denying them their day in court, forced arbitration allowed toxic office cultures to flourish and emboldened sexual predators to operate with impunity. And for each one of the survivors before us today, imagine the thousands of forced arbitration schemes that worked. The employee who really needed that job, scared into silence. The person forced to look for other work in another field after being fired for reporting their sexual trauma. The colleagues who witnessed a coworker fired for doing the right thing, but who just cannot afford to make the same choice. The new employee who will never know that their boss is a predator because everyone involved in the last incident must remain silent or lose their job. Think of all the employees who went into arbitration. Think of the few who won against staggering odds. Remember that even now, the vast majority still cannot say anything about what they have endured. Remember that there are people who feel comfortable sexually arousing and stalking their colleagues because they know they will never have to go to court or face public pressure. And remember that forced arbitration of sexual assault claims allows hundreds of companies to look the other way. Because in a system that binds employees to secrecy forever, a company with a history of sexual assault and harassment claims against its executives is going to manage that liability by forcing its employees to sign an arbitration clause. In a system that sides with the company 98% of the time, accusations of sexual assault will remain hidden forever. The company gets to pick the judge and the jury, truncate the discovery process, choose the law applied, and prevent all appeals. When the company wins, It can request that the victim pay its attorney's fees. In this context, forced arbitration sounds repulsive, because it is. We have created a system in which American companies are seemingly better off retaliating against victims of sexual assault than taking responsibility and holding the perpetrators to account. Forced arbitration has robbed survivors of sexual violence and sexual harassment of their voice. The 4 victims who appear before us today are only here because a congressional subpoena has compelled their testimony. Without that subpoena, they would still be unable to share their stories. And before we begin, we should take a moment to observe their bravery. They stood up to their harassers. When they were told to stay silent, they resisted. And when they had the opportunity to appear before Congress and in front of the world, they came forward to give their testimony. This is true courage, and this committee and the American people are grateful. These witnesses are not here for themselves. They are not here to restart their arbitrations. As much as we might like to do so, we in Congress cannot change the outcome of those cases. No, these brave women are here for the countless individuals without a voice. Not just women, but all those who have been assaulted and harassed and don't know where to turn. The person who was fired for reporting sexual harassment and just found out they signed an arbitration clause in that mess of papers they were given on their first day, and the new employee who might be the next victim of a predator operating under the protection of forced arbitration. The survivors before us today were silenced by their forced arbitration clauses. They are here to show us what a world with accountability might look like. I, for one, am here to listen. I thank all of you for being here today. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Excuse me. Thank you, Mr. Chairman, for convening today's hearing. First, I just want to thank our witnesses for courageously agreeing to be here today. The Judiciary Committee is charged with safeguarding America's most fundamental rights, and we all know that a right without a remedy is no right at all. We must make sure that the pathways that Americans have to resolve their disputes function properly and are fair to everyone. That is true for our court system and for other dispute resolution mechanisms like arbitration. In fact, Congress enacted the Federal Arbitration Act nearly a century ago, and today arbitration provides an alternative to the cumbersome and expensive process of a civil lawsuit. Arbitration is a process that should be as fair as court, but also easier, more affordable, and much faster. Going to court can be extremely expensive if you are an average citizen bringing suit against a major business entity who has an army of attorneys. As we examine the benefits of arbitration and the areas for reform, we should be careful not to frame the question as one of arbitration versus jury trial in a court. Over the last 90 years, the number of civil cases that reach conclusion through trial has declined substantially. In other words, if you're not in arbitration, it is highly likely your alternative to resolve your dispute is a protracted settlement negotiation involving major attorney fees. We all understand the benefits that arbitration provides. However, if the arbitration system is not functioning properly and is being used to stifle individual rights, we have an obligation to fix it. But any reforms must be done in a way that benefit the parties to the suit and advances the interest of fairness and justice. It would be wrong for us to make reforms that do not benefit the parties to the dispute, but rather enrich the lawyers who seek to exploit suffering and hardship by taking a major cut of any damages that are awarded. Finally, I would like to thank again all of our witnesses for their testimony, particularly the witnesses who have shared their personal stories. Thank you all for taking the time to be here today to help us better understand how our arbitration system needs to work. Thank you, Mr. Chairman, and I yield back.
Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses. Eliza Dushku is an actor, producer, student, and philanthropist. She has been a professional actress for over 30 years and has appeared in numerous television shows and independent films. Today, she is a psychology master's degree candidate in a graduate program in Greater Boston. Tatiana Spotteswood is a first-year law student at Columbia Law School. Previously, she was a business and analytics associate at Affinity. She received her undergraduate degree in philosophy and classics from Brown University. Anna St. John is president and general counsel of the Hamilton Lincoln Law Institute. Previously, she clerked for Judge Risa H. Barksdale on the Fifth Circuit Court of Appeals, or was an attorney with Covington and Burling, LLP. Ms. St. John earned her law degree from Columbia Law School. Endor Newton is Vice President for Legal Affairs and Head of Litigation at LVMH Louis Vuitton Moet Hennessy, Inc. I hope I got that pronunciation right. Before joining LVMH, that's easier, before joining LVMH in 2015, Ms. Newton litigated complex commercial cases for several years in private practice. Ms. Newton began her legal career as a judicial clerk for the first vice president, judge of the International Criminal Court in the Netherlands. She earned her Bachelor of Science degree from Georgetown University and dual law degrees in U.S. and French law from Cornell Law School and the Sorbonne. Sarah Parshall Perry is a legal fellow for the Edwin Meese III Center for Legal and Judicial Studies, part of the Institute for Constitutional Government at the Heritage Foundation. Previous positions include serving as senior counsel to the Assistant Secretary for Civil Rights at the U.S. Department of Education and senior fellow for education reform at the Family Research Council. Ms. Perry earned a Bachelor of Science from Liberty University and a law degree from the University of Virginia School of Law. Laura Henry began her career in the dental field, where she worked for 16 years and earned a degree in dental hygiene from Stark State University. She then chose to leave the dental field and follow her dream of owning her own business in the restaurant industry. After 9 years, she chose to switch careers and now is a sales associate for Wacom Mitsubishi in Canton, Ohio. Miriam Gillis served as the Paul R. Verquil Research Chair in Public Law and Professor of Law at the Benjamin Cardozo School of Law. From 2016 to 2018, she also held the post of Vice Dean for Academic Affairs. Professor Gillis received a Bachelor of Arts from Harvard Radcliffe Colleges and a law degree from Yale Law School. We welcome all of our distinguished witnesses and we thank them for participating today. I'll begin by swearing in our witnesses. I ask that our witnesses in person please rise and raise your right hand. I ask that our remote witness please turn on her audio and make sure I can see your face and your raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witnesses have answered in the affirmative. Thank you, and please be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time limit, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For a witness appearing virtually, there's a timer on your screen to help you keep track of time. Ms. Dushku, you may begin.
Thank you. Good morning, Chairman Nadler, members of the committee. I'm Eliza Dushku, an actress, producer, new mother of 2, and currently a graduate student in my hometown of Boston. I've worked in the entertainment industry from the time I was 9 years old in numerous movies with actors such as Robert De Niro, Leonardo DiCaprio, Halle Berry, and Arnold Schwarzenegger, more recently as the lead in 2 network television series. I appreciate the opportunity to speak to you today about this important issue and will share my experience as a victim and survivor of sexual harassment in the workplace and as someone who was fired and silenced when I attempted to address it. In 2017, I was aggressively pursued by CBS to become a co-lead in a show called Bull. I was told that the role would be a 6-year commitment to play a smart, strong leading lady, a confident, high-powered lawyer meant to counterbalance the existing male lead, and that the role had been written specifically with me in mind. However, in my first week on my new job, I found myself the brunt of crude, sexualized, and lewd verbal assaults. I suffered near constant sexual harassment from my co-star. This was beyond anything I had experienced in my 30-year career. My male co-star, who was also one of the show's producers, would frequently refer to me as legs. He would smell me and leeringly look me up and down. Off script, in front of about 100 crew members and cast members, he once said that he would take me to his rape van and use lube and long phallic things on me and take me over his knee and spank me like a little girl. Another time he told me that his sperm were powerful swimmers. These are just a few examples. These were not lines in the script. They were incessant and demeaning and directed at me in the middle of what was supposed to be a professional workplace. Per my history, I tried to be professional and just do my job, but was relentlessly sexualized, crudely mocked, and laughed at. I began dreading going to work each day and often rode home in silence, on the verge of tears, feeling this confusing shame over not having been able to stick up for myself more. I feared that if I pushed back or reacted strongly, my job could be at risk or my professional reputation could be harmed. One day after I delivered a courtroom monologue that I'd spent significant time rehearsing, my co-star shouted out that he and his buddy wanted to have a threesome with me and began mock penis jousting while the camera was still rolling. Then, as I walked off to my coffee break in between scenes, a random male crew member sidled up to me at the food service table and whispered, "I'm with Bull. I want to have a threesome with you too, Eliza." I was horrified and became physically nauseous. I'd just been humiliated in front of 100 coworkers on the set by the star, and now it seemed it was open season for others to demean me sexually too. My co-star's behavior continued and increased. It was pervasive and mean and intentionally disempowering. It was awful. As vulnerable as it feels to admit, I began to borrow my husband's sweatpants and wore big Timberland boots to work to avoid more comments about my appearance. Over the years, I'd become accustomed to the usual banter that occurs on a set. This was very different, but the multi-year contract I'd agreed to was a big deal, and my drive to succeed was strong. I had received rave reviews from the showrunner, who's the person in charge of the show, and others at CBS. I wanted to make the show work, and I loved the role that had been created for me. I spoke with my manager, and we decided that I would try to address the intolerable sexual harassment I was being forced to endure. I had built a professional reputation and should have been able to speak directly with my co-star as an equal. I specifically asked him to be my ally on set and tone down some of the sexualized comments directed at me, especially because he set the tone for the workplace. Admittedly, I was nervous, but I shared with him how he'd made me feel on set and asked if he'd work with me to rectify this. He responded in feigned shock, "No one is more respectful of women than me. I grew up with sisters." What I found out later was that 40 minutes after this conversation, he texted the head of CBS Studios that I had a humor deficit and he didn't want me on the show. The CBS studio head replied that I was great and made the show better. I was fired the next day. The showrunner told me straight up that after the next episode, I would not be returning. He even suggested that I ask CBS and Steven Spielberg, whose company Amblin co-produced Bull, for my own show because he thought my work was so impressive. Now, I've worked as an actress since I was a child and signed countless contracts negotiated on my behalf, but never understood that there were mandatory arbitration clauses that would be used to keep what had happened to me a secret and would protect CBS and the sexual harassment perpetrator who had blatantly retaliated against me for trying to stop the harassment in my workplace. I was shocked to learn that I had signed away my rights to a public forum before taking a job. Who would ever think up such a clause? Who are these clauses meant to favor and protect? It suddenly became clear, not me. I began to understand how very limited my options were to try to address the prohibited sexual harassment and illegal retaliation I had experienced. In response to a letter from my counsel, CBS handed over hundreds of hours of tape, which included video of the actual harassment. It was captured verbatim on their tapes. No one other than my legal advisors in CBS has ever seen or will ever see those tapes. I was trapped by the binding arbitration clause I had unknowingly signed. For the next year, I found myself pitted against one of the most powerful media corporations in the world, CBS, with its unlimited resources, which was controlled by the men who used the arbitration clause to protect themselves, their profitable show, and to silence me. To this day, whenever my career, my life's work is referenced, my accomplishments as an actor are ignored. I've been reduced to being Eliza Dushku, the actress who was paid off for allegedly being sexually harassed on a TV series. As I hope you can understand, this was not the outcome I desired nor ever expected, but because of binding arbitration, there will never be real justice for me and for countless other victims of sexual harassment and assault. Lastly, there's an irony that I fully understand. I'm getting to break that silence today. Countless others who are bound by arbitration are not so fortunate. I offer my strength and solidarity to all the other brave women who will speak today. We can help end this. Accountability and transparency aren't partisan issues. Thank you for hearing me and for considering this important legislation.
Thank you. Ms. Spotteswood, you are recognized for 5 minutes.
Thank you, Chairman. I first met Zia Chishti, the multimillionaire founder of Invisalign and the founder and CEO of Affinity, when I was 12 or 13. He was a business associate and friend of my father's. He would take our family out to dinner when he was in town. My father owned Affinity stock and believed that he and my mother would retire very comfortably from that stock. When I was in my senior year of college, in December 2014, Chishti, who was 43 at the time, invited me on a ski trip. I was 21. I initially declined, but he insisted that he wanted me to meet his nephew, who also studied philosophy, so I agreed. I later learned that the nephew, who never showed up, didn't exist. The trip was designed to groom me. Chishti told me he had feelings for me and showed me an extravagant lifestyle. I rejected him then, but after he persisted in pursuing me, 9 months later, I agreed to date him. After spending time together about 5 times over 10 weeks, I broke off the relationship. Months later, Chishti encouraged me to join his company. He presented a rosy picture of a great career opportunity. Naively, I believed him. Chishti assured me that he did not expect a sexual relationship. In April of 2016, I signed a contract with Affinity that included an arbitration agreement with a strong confidentiality clause. I did not know what that meant at the time. I was just excited and relieved to be making $60,000 a year. As it turned out, Chishti was not willing to treat me like an employee. Instead, over the next 18 months, he oscillated between pressuring me for sex and punishing me. When I rebuffed him, he humiliated me in front of coworkers and then ignored me completely, causing me to fear for my job. Early in my employment, I declined to go to Cuba with Chishti and a friend. He was very angry and refused to speak to or acknowledge me for months. During a work meeting in Dubai, he put his hand inside my pants and grabbed my butt in front of coworkers. No one took any action on my behalf. During that same trip, he turned his attention to another 20-something female employee, also the daughter of someone Chishti called a friend. The next morning, she texted him that she felt violated, that she had asked him to stop many times, and that he knew how drunk she was. Affinity executives and Chishti arranged for her to fly home early and later paid her a secret settlement, and the company did nothing to protect other Affinity women, including me. Chishti orchestrated evening social gatherings for his employees in far-flung locations where heavy drinking was the norm. I never saw any company sexual harassment policy or training. When I asked the head of my office what I should do, he suggested that I avoid Chishti. Chishti made that impossible. As the CEO of the company, he had power over my life and career, and I was anxious not to insult him or make him mad. I explained that I didn't want to have a sexual relationship with him in as many different ways as possible. I said it in person, but I also wrote it in texts and emails. I reminded him in almost every interaction that we had. I told him that his demands were causing me extreme stress, including panic attacks, as well as forcing me to look for work elsewhere. He repeatedly got angry at me for rejecting his advances, such as when he requested to buy me expensive clothes. He called me a bitch in front of coworkers when I refused to hold his hand. In just one email in January 2017, I wrote to Chishti, "3 times you have behaved inappropriately and with my explicit non-consent." I reminded him that I had said to his face, "Zia, this is not consensual. I don't want this." I told him, "These experiences were frightening, degrading, and embarrassing for me. I do not trust you when you are drunk, and these experiences make me feel scared and apprehensive." Instead of changing his behavior towards me, Chishti became more hostile. In writing, he called me petulant, accused me of playing angsty games, and he told me I needed to fix my behavior. In the weeks before performance review with Chishti of my Brazil accounts, Chishti's suggestions became more and more violent. I summoned my courage and told him that his sexual demands made me fear that I was going to lose my job and were causing me to have panic attacks. In response, he sent me 2 pornographic emails describing his rape fantasy, including strangling me while having sex. I was stunned and horrified and tried to ignore them. In Brazil, I avoided him as much as I could, but was under increasing pressure from him. I began to worry that in addition to wanting sex, Chishti wanted to hurt me and punish me for rejecting him. After my presentation, I attended dinner with Chishti and colleagues. Later that night, I went to the hotel bathroom and texted him that I was sick and going back to my hotel. Chishti replied that he would meet me there. I said I was vomiting. He said he was on his way. I admitted that I was still at his hotel. I felt completely trapped and hopeless. I was 23 and very far from home. I didn't want to lose my job. I didn't want him to get any angrier. I did not feel that anyone would protect me, and I was too tired to argue with him anymore. I went to his room where he beat me while having sex with me. I told him he was hurting me. He said, "Good." He told me he should have had sex with me when we first met when I was 13 years old. When I left, he said, "We should do this more often." I hid in my hotel room until my flight the next day. My body was covered with scratches, cuts, and contusions. I had bruises around my neck that looked like I had been strangled, a large bump on my head, and a black eye. A nurse at the hospital said that I had the symptoms of a concussion. And Mr. Chairman, I seek unanimous consent to enter into the record 2 photos of my neck and face that day at the end.
Without objection.
Thank you. As soon as my lawyers contacted Affinity, Chishti initiated an arbitration against me. He knew that the secrecy of arbitration would protect him. 9 months later, just before my deposition, to punish and scare me, he sued my father, who had quit the day I returned from Brazil, in secret arbitration. In May 2019, the arbitrator in my case ruled that I had been sexually harassed and assaulted by Chishti. Since then, Chishti's lawyers at Morgan Lewis have tried to get me to vacate the arbitration award. In exchange for erasing the arbitration ruling, they offered to let me keep the money awarded, drop the claim against my father, and give my father $1 million. They sued my father and then offered to give him $1 million if I erased the ruling, probably so Affinity and Chishti could hide it from his future victims and from potential shareholders if the company goes public. And it's still not over. My father's arbitration has been going on for 3 years, and it has already cost him tens of thousands of dollars in attorney's fees. The harassment and assault I endured were hard enough on my family, but we still managed the financial and emotional burdens of being sued by my abuser in secret arbitration. Chishti still has power over me. He's still able to frighten me. Forced arbitration is the reason Chishti is able to carry out this ongoing campaign of retaliation against me, my family, and probably other victims. Today, as I speak here, I am afraid of the consequences for my family that will arise from my speaking out. I have PTSD, I have nightmares. I used to be a very social person, and I no longer am. The person who changed my life forever continues to abuse me because forced arbitration gives him the power to do it in secret.
Are you finished? Thank you, Ms. St. John. Thank you. Ms. St. John, you're recognized for 5 minutes.
Chairman Nadler, Ranking Member Jordan, members of the committee, thank you for inviting me to appear today. It is my honor and privilege to be before you. In my few minutes, I'd like to discuss how arbitration can provide an alternative method of resolving disputes by which parties can avoid some of the shortcomings present in our civil justice system, and why removing it as an option for dispute resolution is not in the best interests of those subjected to sexual harassment and assault. Studies show that arbitration provides a faster and less expensive way for employees and consumers to resolve their claims against their employers and other companies, and to obtain greater relief on average than they receive through litigation in court. Arbitration tends to be more flexible, both in terms of the formality and scheduling of the proceedings, making it easier for claimants to participate. It involves less burdensome discovery and less adherence to traditional rules that may make litigation in court inaccessible and overly intimidating. There are organizations that support arbitration proceedings to provide some uniformity and to increase accessibility and fairness for individual claimants, while also helping to lower the costs for employees bringing claims against their employers. Employees may also realize secondary benefits from arbitration. Because arbitration is a faster and less expensive way of resolving disputes, companies may have more funds to devote to employee benefits or to lowering costs for consumers. The judicial system itself, including the U.S. Supreme Court, has expressly recognized the benefits of arbitration. And Congress, of course, recognized benefits as well in passing and maintaining the Federal Arbitration Act, which has been in place for nearly 100 years. So when we talk about the problems with arbitration clauses, I think it's important to keep in mind that arbitration is not necessarily a danger or impediment to those who have experienced sexual harassment or assault in the workplace or elsewhere. Instead, it's worth considering that taking away the possibility of arbitration for these victims is a top-down, heavy-handed approach that denies them the advantages of arbitration as a means of adjudicating their claims. It's also worth keeping in mind that an agreement to arbitrate does not impact a party's substantive claims. A claimant retains the same rights as she would in court, but simply submits her claim to adjudication in a less formal setting. Perhaps in recognition of this fact, courts allow parties to arbitrate even grave injuries, such as claims involving wrongful death. The court system is not necessarily the answer to concerns about arbitration. Overburdened courts are often slow-moving, and as a result, it is the attorneys who benefit from the prolonged resolution without any proportionate benefit to the victims. Class actions do not provide a solution either, as sexual harassment and assault claims are often too individualized for class treatment, and in any event, class actions are slow-moving and often disproportionately benefit the attorneys while inefficiently distributing relief to the victims. Sexual harassment and assault victims may also prefer arbitration because it allows them to choose to keep the proceedings confidentially. Unfortunately, these claims continue to often carry a stigma that victims may want to avoid so as to continue their day-to-day lives without suffering professional damage or negatively impacting their ability to earn a living. While the public nature of a handful of high-profile cases has had a positive trickle-down effect, the same is not going to be true for many more routine sexual harassment cases. These victims should not be forced to have their claims adjudicated publicly, and in fact, many would likely forego bringing claims at all if they could not be handled privately, such as through arbitration. Arbitration in itself is a process that would not prevent victims from reporting criminal conduct or the underlying facts of the claims if they choose. Concerns about confidentiality agreements and NDAs can be addressed without taking away the positive advantages that arbitration can provide. Thank you.
Thank you. Ms. Newton, you were recognized for 5 minutes. You put it on your mic?
It's my first time. Chairman Nadler, Ranking Member Jordan, and distinguished members of the Judiciary Committee, thank you for inviting me here today. It is an immense honor. I am joined by my father, mother, and 2 of my brothers seated behind me. Before I begin, I want to state that my remarks reflect my personal experience only and have not been made in any professional capacity. And I testify under subpoena issued to me by this committee. While my professional and academic profile may not fit the image of someone rendered powerless by and treated inhumanely through forced arbitration, none of my achievements has protected me from the years of intense retaliation, dehumanization, and degradation to which my employer, LVMH, has subjected me. In December 2014, I was offered the position of Director Litigation Counsel for the American affiliate of LVMH Moet Hennessy Louis Vuitton, the French conglomerate with brands like Dior, Dom Perignon, Fendi, Givenchy, Veuve Clicquot, and Rihanna's Fenty. I was ecstatic. It was my dream job. I attempted to negotiate several aspects of my employment agreement, but LVMH made it clear that no aspect, including the forced arbitration clause, was negotiable. It was a take it or leave it offer. I accepted, and achieved glowing, flawless performance reviews. My boss, the US General Counsel, wrote, "Endor reflects the highest degree of honesty and ethics in all she does and handles all matters with a calm demeanor." I was soon promoted to Vice President Legal Affairs. But I was also being sexually harassed by LVMH's Director of Property and Facility Operations, Lloyd Doran, a white male about 30 years older than me. He supervised a large staff, reported directly to an SVP who reported to the CEO, and was part of the most senior executives' inner circle. I barely knew him when he began leering at me every time he saw me. He would walk by my office very slowly, skimming the doorway. That escalated to him lurking directly outside of my office for such excessive periods of time that a colleague confronted him about it. At work gatherings, he pointedly leered at me, and as soon as I entered the room, would suddenly appear near me. The fact that he monitored all security videos and oversaw security staff especially concerned me. I repeatedly rebuffed his advances, but that had no effect. One day, he entered my office with the excuse of hanging artwork. Suddenly, without warning, he lunged towards me, thrusting his pelvic area into my face as I sat at my desk. He pinned his body horizontally on top of mine. I exclaimed in shock while trying to unpin my body from under his. After I was able to stand up, he pretended that he had done nothing wrong despite my protests. This left me constantly agitated and distressed, preoccupied with avoiding the trauma of encountering him. I listened out for the ding of the elevators, avoided the stairwells, or working very late in the office, and when I had to, barricaded myself inside my office to try to feel safe. When he continued to lurk outside my office, I became anxious and stressed to the point that I had tremendous difficulty concentrating on my work. It was persistent, disruptive, and suffocating. You would think all you need to do to stop things like this would be to report it. I, too, thought that would end it, but the opposite was true. I was about to receive a horrifying lesson on the power of forced arbitration. In the following days, LVMH ignored my verbal and written reports and failed to do anything to stop it. They instructed me to personally confront him despite the concerns I expressed. My supervisors even reported me for confronting him, and then they investigated me. They disregarded my colleague's testimony who had witnessed some of the behavior and confronted him. Company management even went so far to suggest that I should apologize to him. Ultimately, management blames me for misinterpreting the leering, constant attempts to be near me, and the attempted assault, calling it mere flirtation based on my misunderstanding of French culture, even though Lloyd is American. And I spent many years, as you heard, studying and living in France. They told me this is what executives do in a French company. They seem to justify his misconduct because the general counsel felt, as professional women, there are certain things we have to put up with and sacrifices we have to make. After repeatedly rejecting my request to engage an experienced unbiased investigator, LVMH suddenly reversed course and paid for an outside investigator. But she was unable to keep the facts straight, suggested I should be flattered by the harassment, and asked me if I wanted to keep my job, and warned that I would look like a troublemaker and a son of a bitch, excuse my language. Then, even before completing the investigation, LVMH promoted Lloyd and publicly announced his promotion to all employees at a company event. The investigator initially proposed issuing Lloyd an internal restraining order, but after conferring with LVMH, her final report was modified. Emboldened, Lloyd strutted around the hallway outside my office more than ever. My boss began lowering my annual evaluation ratings and inserting hypocritical and snarky comments. She excluded me from high-profile projects and warned that she would be keeping an eye on me. LVMH left me with no choice but to file a lawsuit. They immediately tried to force my case into arbitration, threatening my attorneys and jeopardizing my career and my livelihood by seeking sanctions against me personally. The CEO then emailed all employees, essentially calling me a liar, misstating LVMH's knowledge, denying any retaliation, and mischaracterizing the investigator's results. He also pretended that a new system created solely for anti-corruption issues suddenly had a secondary function of receiving sexual harassment reports from employees. LVMH repeated similar lies to the press and the court. In 2020, I had to be hospitalized twice due to a serious physical issue, likely triggered by the trauma and stress LVMH incessantly inflicted on me. My case is now in forced arbitration, and I have witnessed firsthand some of the numerous ways it is biased and unjust against survivors. Forced arbitration and the power it provides to employers seems to have emboldened LVMH, who ramped up their retaliation, gaslighting me and inferring that the sexual assault and harassment were figments of my imagination. LVMH has been so relentless in forced arbitration that I had to take unpaid medical leave this year due to their personal attacks. By leveraging forced arbitration, LVMH potentially endangered other employees. Had I not filed a complaint, LVMH would have permitted Lloyd and perhaps others like him to continue working there to this day. Because of forced arbitration and confidential settlements, I may never know the extent to which Lloyd sexually sexually assaulted or harassed others, or if LVMH retaliated against others as they did me. Thank you for unsilencing me today. You each stand in a position of far more privilege and power than most Americans could ever dream of. I hope that you use that position to protect us and your loved ones by ending forced arbitration.
Thank you. Ms. Perry, you are recognized for 5 minutes.
Good morning. Chairman Nadler, Ranking Member Jordan, members of the committee. Thank you for giving me the opportunity to appear before you today. I commend this committee for holding a hearing on an important topic. Today's hearing is, unfortunately, to quote the great Yogi Berra, deja vu all over again. Since the 1980s, the progressive leadership of this and the upper chamber has sought to curtail the protections of the Federal Arbitration Act through bills including the Arbitration Fairness Act, Arbitration Fairness for Students Act, Consumer Mobile Fairness Act, Fairness in Nursing Homes Act, Consumer Fairness Act, Restoring Statutory Rights and Interests of the States Act, the Forced Arbitration and Justice Repeal Act, and many, many more. In enacting the FAA, Congress sought to redirect employment disputes away from congested court dockets and to experts in employment and labor law. So congested are these court dockets today, in fact, that between 2019 and 2020, the number of civil filings in the federal district and circuit court system increased by 40%. Judicial delay is one of the largest problems in our American legal system. Many of the cases that are in the system take more than 3 years to reach a resolution, and every study considering the issue has concluded that results in arbitration are far swifter than litigation. Time and again, the Supreme Court has also interpreted the FAA to be a liberal federal policy favoring arbitration, and has clarified that arbitration may be applied to anti-discrimination employment provisions like sexual harassment claims and Title VII. It routinely assumes that litigation and arbitration are equally acceptable methods for resolving disputes, and has consistently so held. Data indicates that only 1% of all civil cases filed in federal court ever go to trial. The basic premise of all limiting legislation, that arbitration is somehow unfair to or bad for employees and consumers, is false. The evidence shows precisely the opposite. Empirical studies show that employees do as well or even better in arbitration than they do in litigation. They prevail at the same rate or more frequently. They recover as much or more through arbitration as they would in litigation. And in a study of more than 100,000 cases, the claim of employee plaintiffs in court compared with arbitration showed that those arbitrating generally recovered approximately double those in court. The FAA also enforces neutrality requirements for arbitrators. It authorizes federal courts to vacate arbitration awards where there is evidence of partiality in the arbitrators. There are also remedies that exist in law to invalidate arbitration agreements, which protects employee claimants when the balance of power has been weighted against them. In a study performed by economics firm Micronomics, when totaling both direct and indirect financial losses associated with choosing trial over arbitration, estimated total losses were calculated at approximately $28 to $35 billion between 2011 and 2015. When calculated for additional time through appeal, the losses rose to a skyrocketed 51 to 59 billion over the same time period. And last, and most importantly, interest groups for years have identified arbitration clauses as untenable, in large part because they claim it creates confidential proceedings that remove bad corporate actors from the sanitizing light of publicity. But this conflates arbitration with confidentiality clauses, two distinct things. The American Association of Arbitration, in its due process protocol, says that only the arbitrator shall maintain the confidentiality of the arbitration and has the authority to make appropriate findings to safeguard the confidentiality unless the parties agree otherwise. This is a duty for the arbitrator alone. In fact, neither the FAA nor the Uniform Arbitration Act imposes any duty of confidentiality on the parties to an agreement. The arbitrator or the arbitration administrator and is silent on the privacy of the arbitration process. These are contractual causes that appear on their own. While the public cannot attend arbitration hearings and an arbitrator and arbitration administrator cannot disclose information about arbitration, the parties to the contract are under no such obligation unless they explicitly agree. Even in arbitrating employment discrimination claims, an employee can disclose the facts of the underlying dispute, can disclose information obtained in the process and the amount of any award unless they have explicitly agreed to confidentiality provisions. They can still report, communicate, and disclose the disposition of their Title VII discrimination claims, as well as harassment, retaliation, and sexual abuse claims. They can always communicate with federal and state agencies, and they may file and pursue a claim through the EEOC or an investigation in the public interest. We do not want to protect bad actors, but these are two distinct realities. Under U.S. law, arbitration is not really a confidential process, it is a private process. And it's not that arbitration clauses are dangerous, but perhaps that confidentiality provisions are. There is a culture of sexism, even predation, within the halls of power. The Larry Nassers, the Harvey Weinsteins of the world, they deserve to be called to account. I commend the personal bravery of the women here today. They have been fundamental to the service of justice for not only themselves, but for so many others like them, simply by sharing their stories. But the very premise of this hearing, that arbitration keeps victims of sexual violence and harassment in the shadows, suggests a solution to the problem of harassment and discrimination that's ultimately misguided. Arbitration agreements are not mandatory. No one, and the Supreme Court has held, is forced to sign a contract. But curtailing access to arbitration would injure, in the end, the very people that Congress has sought for nearly a century to protect. Thank you.
Thank you. Ms. Henry, you are recognized for 5 minutes.
I want to begin by thanking the committee for the opportunity to share my story and for recognizing the ongoing harm that mandatory arbitration requirements have caused to me and countless other women who have been sexually harassed on their jobs. Without this committee's request for my testimony, no one would ever heard my story, other than the one single arbitrator in the closed room with a couple of attorneys. My name is Laura Henry, and I'm a former employee of Ken Ganley Kia in Medina, Ohio, and this is my story. Like many, when I was hired, I had a mess of papers in front of me and was told to sign here, here, and there. Just HR stuff, I was told. I did not know at the time that I had signed an arbitration agreement. While working at Ken Ganley Kia, my boss, Mike Gentry, grabbed my butt. He pinched my nipples. He repeatedly made comments about my body, including that he could see my vagina through my pants. He bragged about getting blowjobs from customer in exchange for gift gas cards. I hope we can all agree that this is pretty disgusting behavior. I wish it ended there. It did not. On my birthday, Mike Gentry showed up at my house unannounced with a bag of sex toys as gifts. I had to tell my boss to get out of my house. Unhappy with this answer, he later offered to pay me for sex while at work, like I was some kind of whore. When I told him no, he tried to put the money down my shirt. I was disgusted, I felt alone, and I did not know whether this had happened to other women, too. Had other victims been silenced with the secret arbitration? I found myself worried that I had offended him by rejecting his advances and kicking him out of my house, that I'd be fired. I dreaded going into work. Every drive into work, I thought, well, what will he do today? I would worry about how he would react to my choice of clothing. Do you know how mentally exhausting it is to be on guard every second for a hand that could come out of nowhere and pinch or grope? I feared that reporting this sexual harassment to Ganley Kia would cost me my job. Mike Gentry is the face of Ganley Kia's Mike and Darwin, an advertising campaign on local and social media. I, on the other hand, was just one of the many sales representatives. Right before Christmas 2020, Mike Gentry appeared at my home, again unannounced. When I cracked my door open, Mike Gentry grabbed the door, pulled it open, and pushed his way in. He said he had gifts for me. My heart sank. He pulled his pants down and stuck a large syringe into his penis. It would help him get an erection, he told me. I feared that he would rape me right there. I screamed for him to get out of my house as loud as I could. That was it. I finally reported it, hoping that I was wrong and that my employer would do the right thing. Unfortunately, everything I had feared about reporting this sexual harassment came true. Ganley Kia did not take my complaint seriously. They conducted a sham investigation and said it was my fault. My fault? In what world is the woman to blame for a man showing up at her house with sex toys and injecting his penis? I now know that they felt like they could make these absurd attacks on me because they knew that no one, except an arbitrator, would hear their lame defense of a sexual predator. They involved their lawyers to protect the company and their star sexual predator, who they continued to put on their advertising. He and the dealership retaliated against me by cutting off my sales leads, which took away my sales and commissions. And when I still would not quit, they fired me. They just wanted me to shut up and go away. I wanted to hold Mike Gentry and Ken Ganley Kia accountable. I believed that if I stayed silent, he would be free to continue preying on women, and Ganley would allow it. I wanted to stop him. So I gathered all of the courage that I could stomach and fought a lawsuit. But they filed a motion to dismiss because of the sign here, here, and there arbitration agreement. They stole my right to a jury because you allow women like me to be silenced by arbitration. Mike Gentry will never have to stand in front of a jury and explain himself. I cannot sit here today and tell you whether Mike Gentry has victimized other women. I cannot tell you whether the Ganley dealerships have fired other victims who complained about sexual harassment. I cannot tell you whether Ganley has systematically buried other instances of sexual harassment in its 40-plus dealerships in Ohio. I cannot tell you any of this because you have given Ganley the right to keep all of this in the shadows of arbitration agreements that are buried in the hiring paperwork. What I can tell you is that this cycle of sexual harassment will continue if you force women to be quiet and allow sexual harassers and the companies that allow them to hide behind arbitration agreements. This is my story, but it is also the story of countless other victims of sexual harassment and future unnecessary victims. So I ask, do you want to force sexual predators to explain themselves in front of a jury, or do you want to put sexual harassment victims back in the little silent box so that people like Mike Gentry can keep being the face of Ken Ganley's advertising? This is not political. This is morality. Do you side with the sexual predators or their victims? Thank you.
Thank you. Professor Gillis, you were recognized for 5 minutes.
Chairman Nadler, Chairman Johnson, Ranking Member Buck, distinguished members of the committee, I want to thank you for having me back to talk about these important issues. It's my privilege to be here and my sincere privilege to sit next to these very, very brave women. Thank you so much. I've been here before to talk to you about how terrible forced arbitration is. I've talked to you before to try to get you to sign and enact and support a bill that would get rid of these pernicious clauses across the board for all employees and all consumers. But that's not for today, because today we don't all have to agree that forced arbitration is terrible. Across the board, it's terrible, but hopefully I can come back and try to persuade you of that on some other occasion. Because today we're here to talk about HR 4445, a bill that would prohibit employers from forcing victims of sexual harassment and violence into arbitration. And on this, I sincerely hope we can agree. 3 of the witnesses have already said this is not a partisan or political issue, and I certainly hope that you're receptive to that very clear message. Because the truth is, I can't imagine, really, I can't imagine how you could design a worse system for dealing with sexual harassment than forced arbitration. I mean, it's just the worst possible regime. First, the entire regime is shrouded in secrecy. And not just because victims want to keep these issues confidential, which, by the way, is up to them, right? They should have the autonomy and the choice to decide. But because companies want to keep this stuff under wraps. They want to hide and shield sexual predators, and they don't want their business in the public eye. They don't want to deal with regulators or even with lawsuits. The secrecy here on its own just makes this a terrible way to deal with sexual harassment, because it means that victims of sexual violence in the workplace who bravely try to come forward are prohibited from telling their stories in a public forum. Instead, they're forced into this private process where everything is under wraps and siloed, right? So this is the second bad thing. Victims can't join together, even when their injuries stem from the same wrongdoing, even when they've occurred at the hands of the same perpetrator, even when the company's tolerance for sexual harassment is structural and pervasive, victims have to go it alone, never knowing about one another. They have to go into arbitration single file. I don't know where all these statistics are coming from about how great arbitration is, how people win it all the time, because the truth is, no one goes into arbitration because it's siloed, because it's secret, because they don't know about what else is going on in the workplace. The secrecy that blankets these individualized proceedings prevents one victim from ever learning whether others right in the cubicle next to them might have experienced the same tragedies, the same traumas. And when survivors are in the dark about cases filed by others in the workplace, that makes coming forward, that makes being the first person to come forward that much harder. As a corollary, and this is an important corollary, the relief that is available to the individual claimant doesn't prevent the wrongdoer from preying on other women, doesn't prevent the predator from having all sorts of misconduct against other women in the workplace. The proceedings are one-on-one, and the relief that arbitrators are allowed by contract to grant is individualized. They can't ever order any changes beyond what can help this one individual that happens to have the courage to come before them. I mean, can you imagine a worse system for dealing with toxic corporate culture? Because I can't. Third, and I think this is really important, and all the survivors have spoken about this, forced arbitration is a system where the employers write the rules and they pick the arbitral provider, which means that victims of sexual harassment are shunted into a regime that's stacked against them from the get-go. First, because the arbitrator's economic interest is to be very good to the repeat player employer so that they can be chosen for another arbitration next time. So the repeat player problem has been well documented, and I think it's alive and well in arbitration, and the secrecy protects that. And second, because the employer designs the entire arbitration process, it does so to serve its interests, not the interests of its workers, but its interests, which again are to keep discrimination and harassment under a veil of secrecy and out of the public eye. So given all of these things, given how bad this system is for victims of sexual harassment, it's no wonder that so few ever decide to go into private arbitration. I wouldn't. I think it sounds terrible. Because the truth is that, you know, we can't reform this system as Ranking Member Jordan I think expressed in his opening that maybe this is a system that can be fixed. I challenge you to really find a way to do that, because it's broken and it doesn't work. And moreover, none of the victims want it, right? So you can't fix it if it doesn't work. And I don't think it works. These victims deserve the right to decide for themselves where and how to file a case. They deserve to be free from retaliation for complaining about the treatment that they've suffered in the workplace. They deserve to tell their stories and to have us hear their stories, to have you hear their stories, and to hold perpetrators and employers accountable for pervasive misconduct. None of this is possible in a system of forced arbitration. So I urge you to support and enact this bill and I'm happy to answer any of your questions. Thank you for having me.
Thank you. Thank you all for your testimony. We will now proceed under the 5-minute rule with questions, and I will recognize myself for 5 minutes. First off, I want to thank all of you for coming before us to share such personal and traumatic experiences with us today. We're incredibly grateful. Your testimony will help save countless other women from being victimized in the future by sexual predators in the workplace. Ms. Spotteswood, your attacker did not attempt to conceal his actions. He operated in broad daylight. You, on the other hand, were forced into a secret closed-door proceeding. Prior to joining Affinity, you had no idea if your attacker had previously acted like this toward anyone else at the company. Do you believe that secret arbitration proceedings endanger men and women in similar situations?
Of course, even at Affinity, I don't know whether there are women there who, like me, might think that they are the only person that this has happened to, and like me would have to wait until months into an arbitration proceeding to learn that there are other victims.
Ms. Henry, I'd like to ask you a similar question. Your harasser also operated brazenly and without fear of repercussions. If there was someone at the dealership before you who was able to take their claims to court, do you think your attacker would have repeatedly harassed you after you were hired? Put your mic.
No, sir, I do not. I feel like I wouldn't be sitting here today if that would have happened previously and it was taken care of at that time.
Ms. Newton and Ms. Dushku, you both described work environments in which senior management brushed aside the reports of the sexual harassment you endured. In your view, how would prohibiting arbitration clauses from being enforced in cases of sexual violence and harassment reform workplace cultures that ignore or protect repeat offenders? Ms. Newton?
I think it would send the message immediately that there is no tolerance for this in the court of law. They would know that going in. We cannot get away with this. Right now, they feel like it's open season.
Ms. Dushku, what do you think?
Short answer is accountability. I think that transparency and openness have to be a part of this because transparency makes the perpetrators in sexual harassment accountable. Accountability changes behavior. I think in my situation, if people could have seen the tapes, accountability would have changed the outcome.
Thank you. Professor Gillis, with the time I have left, could you highlight the breadth of forced arbitration's impact on sexual assault and harassment cases?
Yeah, of course. So, it starts at the very beginning. A woman, a victim of sexual harassment, tries to complain about her treatment, and she doesn't get anywhere with HR, so she tries to file a lawsuit, but as Ms. Henry indicated earlier, and I think her story is a story of so many women in this situation, she learns only upon speaking to a lawyer, reviewing documents, that she signed something somewhere that she doesn't even remember. None of us remember all those documents they give us to sign on orientation day. And in there, tucked in the very deep, deep fine print, is a forced arbitration clause that says that you've waived your right to a jury. You have to go into a private arbitration pre-designated by the employer, who's retained that arbitration provider, so you're not very sure how fair the proceeding will actually be. In arbitration, for this apparent speed and cheapness, we get very, very streamlined proceedings, so streamlined that the rules of discovery and the rules of evidence and other procedural protections that would apply in court no longer apply. And so right off the bat, we're just treating these people as though they're second-class citizens. When an arbitration complaint is filed in secret. In other words, the only entities that know that the arbitration has even been filed are the employer, the complaining employee, and the arbitration entity, the AAA or JAMS or one of these arbitration providers. Nobody else knows. Contrast that with court. If I go down to the DC District Court today and I file a complaint, that complaint is on the public record. right? And so is the defendant's answer or motion to dismiss, all the pleadings, they're public. Litigation in the public court system, it has power, and the power it has is the power of signaling, not only to the defendant that I've sued, but to all similarly situated defendants, that this is a wrong. This person has complained about something, she's told her story, and she plans to prove it. None of that happens in arbitration. From the beginning, it is private throughout the entire proceeding, which is held in a secret location, no public, no press. All of it is private. Arbitrators don't write decisions. There are only 3 states in the union that currently require minimal disclosure of arbitrations, pretty redacted and hard to read if you're a researcher like I am about these issues. Other than that, everything that happens in arbitration is a black box. And so should we be surprised that women are feeling incredibly angry that they don't get to tell their story, that they don't get to know whether the place they choose to work is full of problems that they never learn about? This is overwhelmingly bad, right? This is, as I said in my opening remarks, I think the worst possible system one could design to deal with a problem of this nature.
Thank you. I would ask our witnesses to please put their masks on when they are not speaking. Mr. Shabbat is recognized for 5 minutes.
Thank you, Mr. Chairman. And I also, it's already been mentioned, but I want to thank the witnesses for being here today as well. This is obviously not an easy thing that it is to testify in public like this, and we certainly appreciate your bravery in doing this. And I think the behavior that's been discussed here is obviously outrageous and disgusting, and most of the individuals who you've been talking about on the other side ought to probably not only be sued or gone through arbitration, as the case may be, civilly, but ought to be behind bars. So I think the behavior that's been discussed here is criminal. And I know that as time passes and we as a society become more and more educated about this and how often it occurs, you know, we take it more and more seriously as we ought to. So again, thank you for being willing to be here today and to tell us about this. And as I say, most of these guys you're talking about ought to be in jail. Now, that being said, obviously we've had federal arbitration and there's arbitration at the state level. It's been around for a long, long time. And it's one way to handle these types of things, not the only way. And there obviously ought to be more thought given up front, I think, on both sides about these contracts. And it's disturbing that such little time is given for an individual like yourself who's signing on at that employment early on as to what rights they may or may not be giving up. So I think that's something else we need to take a strong look at, is let's find out what people are actually signing. You know, they tell you, you know, never sign anything unless you read the fine print, you know, whether you're purchasing a car, whatever the case may be. And let's face it, we're all busy. They put stuff in front of us and we sign
Would the
it.
gentleman yield?
I'd be happy to yield.
Yeah, but isn't the whole point that these women and others similarly situated are given contracts to sign? Here's your employment contract, and you may not X out the arbitration clause or the NDA, take it or leave it, and that's what we're dealing with.
Yeah, reclaiming my time, I agree with that, and I'm saying that's something that we do need to educate the public, and we all ought to be involved. You know, yes, we've got Democrats and Republicans here, but this is an issue I think we ought to be united on and ought to be out there protecting women or men in some cases that are harassed either at the workplace or any place else. You know, this is my 25th year in Congress, and on this Judiciary Committee, we handle an awful lot of very important issues, and most of us on both sides have supported programs and policies to protect individuals and assist victims of sexual exploitation, either in the workplace or in other places. So I think this is a timely, you know, discussion of this. But I've talked much longer than I wanted to. I want to get in a couple of questions. So obviously, the two rivaling principles here are, you know, getting justice certainly for a horrific thing that this individual has undergone, but doing it in a manner which, with all the lawsuits that are filed in this country, doing it in a timely way and doing it in a manner where you're going to get justice. And so I'd like to ask Ms. St. John and Ms. Perry, you had mentioned, Partial Perry, you had mentioned before about the time that is that you can get your case before the adjudicatory person, which in this case would be an arbitration panel. Oftentimes you have each side picks one, and those two arbitrators pick another arbitrator. So could you discuss that? You did somewhat in your testimony about the benefits of going that route. And is there anything that you would suggest in perhaps the discussion that I mentioned about having people more educated up front when they sign these employment agreements, that they're actually giving up their rights? And I'd let either one of you take that.
No, I think that's exactly right. Not every employer has these mandatory arbitration provisions. And I think if going in, employees know that there are employers that have them, there are employers who don't, maybe some are willing to remove them or talk through them, that would be helpful. And, arbitration does tend to be a faster, cheaper, easier way of resolving disputes, and that may be a way that is more beneficial to victims of sexual harassment and assault or any other workplace violation.
Thank you for that question, Congressman. I would echo what Ms. St. John said as well. I think also we need to refocus our analysis toward confidentiality and NDAs. And when those accompany arbitration provisions, that is a particularly pernicious setup. And in fact, 5 states have enacted legislation that indicates in certain claims under employment discrimination law, you may not use an NDA or a confidentiality provision. And so you are automatically given the opportunity to go immediately public, even though you are still in the arbitration process. I do think there's much to be said for investigating how we can look at the confidentiality provisions when they accompany arbitration itself.
Thank you. My time's expired, Mr. Chairman. Yield back.
The gentleman yields. Ms. Jackson-Lee.
Thank you. Let me thank you all for your bravery and courage. I don't know how many words I can offer that would equate to what you have done, not for this committee, but for America today. Each and every one of these persons in normal circumstances committed a crime, should be tried and incarcerated. But here we are with a mystery that most of you did not realize was part of your contract. That in and of itself is not the American way. So I do want you to feel that you have contributed to a further understanding and empowerment of lawmakers to distinguish between what arbitration may be of value for and where it is wrong, ugly, and bad. I do want to quickly, Ms. Spotteswood, you indicated in your testimony that there was another young woman who was harassed and assaulted on an international trip. Do you believe Christie has a pattern of luring young women out of the country and assaulting them, which changes the whole framework of your legal rights?
I personally believe that. It's certainly, there were a lot of similarities between what happened to me and the other young woman who I learned about. But yeah, if whatever his pattern is, it won't ever be revealed if he can always set the rules of dispute resolution with his employees.
Ms. Dursky, when Weatherly made a rape joke in front of the cast and crew, and I'm horrified by what you had to experience, film rolling, and your professionalism demeaned, how did that make you feel?
I was horrified. I was embarrassed. I was ashamed in some strange way. It was just incredibly demeaning. And as somebody who, had spent my life and my career establishing myself as sort of this strong, outspoken woman, I felt that it was intentionally directed at me to make me feel small and unable to defend myself.
Almost taking your literal rights away as a independent, as an American. Thank you for that. Ms. Newton, do you have an impression that Louis Vuitton felt responsible for doing due diligence, or did they look like they had concern to really do a thorough investigation of what you spoke about and how you were demeaned, hurt, and harmed?
No, I don't think they had any consideration at all. Everything was done in a really shoddy manner with the intent of burying it.
Ms. Henry, do you think the actions of your perpetrators should have really put him into the criminal justice system?
Yes, ma'am, I do. It's just, right, the way things are there now, it's just a big secret. They can pay some money to the victim and move on and not even warn the next person that this may happen to. So yes, I don't feel like justice has been prevailed here at all.
Professor Gillis, thank you for the research that you have done. You've heard the pain of these women and how I believe these allegations against these perpetrators would really throw them into the criminal justice system. Obviously, one incident happened out of the country. Can you tell us how these incidences are in fact, these policy presence with arbitration, the implications of what they have for justice or injustice now in America?
I think that you're hearing today, the implications are significant. We have a group of incredibly strong women who were demeaned in the workplace. I think that that's injustice right there. But I think it gets worse and worse. So my colleagues on the right have argued that courts are too busy, dockets are too full. And that's the reason to shunt these cases into arbitration, where they can allegedly be dealt with cheaper, faster, easier. And I just want to point out that, first of all, they're not being dealt with cheaper, faster, or easier. They're not being dealt with at all. Very few victims ever decide to go into arbitration. So the company line that the Chamber of Commerce likes to feed us, or some of us, is just false. And so that means that there's deep injustice in that we have a two-tiered system, right? We have a system for big companies who get to go to court, and then we have a system for victims who have to be forced into arbitration. I'd also just say as an aside, if there really is a question about whether court dockets are too full, then this body should just appoint more judges, right? The way to deal with that problem is not to force people into a system that they don't want, they don't need, and is deeply unfair, but instead it's to just appoint more judges. I also think, representatively, I think this is an important point, and that'll be my last point. There's a deep problem and an injury that happens to the law itself when cases are not brought in public courts and are docketed on the public system. We lose something. We lose something about what makes this country great, which is law. And law has to have people, inputs, to develop, to move forward, and to evolve. Right now, a lot of cases are not getting before judges. They're not hearing those cases. And what happens is that law itself starts to stagnate. So I think the harms are cascading. They're multiple, they're deep, and it's time to put them to an end.
Thank you.
Gentlelady's time has expired. And let me just say, Ms. Gillis, that regardless of the topic of this hearing, I think you'll find considerable bipartisan support in this committee for increasing the number of judges. Mr. Jordan.
Thank you, Mr. Chairman. Ms. Parshall-Perry, we got a markup on this tomorrow. And it sounds like Ms. Gillis just talked about public, this information being public, and these courageous individuals who came and shared their story, that information getting public. And you indicated with Mr. Shabbat that you felt the answer to this, to protect the benefits of everything here, and the benefits of all, was to get rid of to deal with the non-disclosure of confidentiality. You think that's the answer? I mean, like I said, tomorrow we're going to be actually potentially passing this bill out of the committee, moving it to the House floor. And we'd like to do it right that's going to treat people who've had to go through the terrible things they've had to go through. We'd like to treat them the right way.
Thank you for that question, Congressman. I do believe confidentiality and those provisions that attach so often to arbitration agreements are precisely the problem that we're dealing with in the first place. And the opportunity for individuals who are signing employment contracts to truly understand that what they'll go through may not ever see the light of day. The explanation, I almost wonder if there ought to be some disclaimers that we investigate, that if those particular claims are given an opportunity to be arbitrated, like any other employment claim, any other discrimination claim, anything in employment and labor, that there is attaching language saying that we will not utilize non-discrimination or non-disclosure agreements, confidentiality provisions, so that immediately upon entering arbitration, the process itself is not private, it is not kept behind closed doors, and there are protections in the Federal Arbitration Act that make note of the fact that there are no confidentiality provisions, and the American Arbitration Association focuses singularly on arbitrators, the goal being to protect privacy during negotiations, but it will be very long before those individuals and their claims actually see the light of day. I do think confidentiality is an issue.
Thank you. I'm going to yield to the Congressman or maybe Attorney General of Texas for the remainder of my time.
Thank you. Ms. Spotteswood, sorry for not knowing, but your attacker, he ever faced criminal consequences?
No, as far as I know, he's still the CEO of this company. In fact, I'm very much afraid of what will happen after this hearing.
Well, that could well be a crime if some retaliation is brought to bear against you. And now that you are public, please don't keep future crimes private. And you're out there, might as well follow up. The law and order side of me says somebody that attacks anybody like you were attacked needs to be responsible. The criminal justice system, not keep it private, but it needs to be dealt with in a criminal court. And I also wonder if that also might be something, whether it's sexual assault, anybody that has a crime committed against them shouldn't be limited to arbitration. It looks like you ought to be able to pursue that. And perhaps, and Ms. Gillis, I understand what you're saying, but in my time as a prosecutor and as a judge, sometimes we have women that really don't want to come forward. And,
Then they
the side of me
shouldn't.
wants them to come forward.
But that's what I think we're
I know
on the same.
you've dealt with that.
We're on the
so-
same page. I just think they should have a choice, right?
Exactly.
So I'm with you,
Yeah,
right? But
yeah.
they shouldn't be forced into a system they don't want.
And just because somebody's part of a labor union doesn't mean they ought to be forced into arbitration either, right?
We're not here to talk about labor unions. That's a whole
Oh,
other
yeah,
hearing.
but that's an exception.
An exception to
Labor
what?
Labor unions will be able to negotiate arbitration agreements. So it is something to discuss, but you may not want to discuss it. Ms. St. John, how do you feel about exempting out agreements made by labor unions from whatever law gets passed?
Well, I think it's inconsistent with the principles involved. If arbitration's okay for some claims, it should be okay for all claims. And same with whatever process is available, it shouldn't be restricted based on whether or not an employee is in a union.
But I can sure see with a sexual assault, a need to give that choice to the victim after it happens and not agreeing before it happens. So I appreciate all of you being here, appreciate your sensitivity, and we'll look forward to dealing with this as a legislative matter. Thank you. I yield back.
The gentleman yields back. Mr. Johnson.
Thank you, Mr. Chairman. Ms. Partial Perry, I've got legislation that would expand the United States district courts by creating 203 additional judgeships. do you believe that that would create efficiencies that would enable more women to be able to bring cases of sexual assault in a court of law instead of in arbitration?
Congressman, I think my primary concern would be filling the vacancies we currently have. And until we can get that figured out, I'm not a fan of expanding unilaterally the judiciary. I think that's a problematic avenue to pursue.
All right, thank you. If we could fill the vacancies, though, it would be great for justice in America. Isn't that correct?
If we could fill the vacancies, yes, absolutely.
You've given up on the Senate being able to confirm judges.
I have not. I do believe the Senate is still capable of following its edicts and making sure that those vacancies are filled. But before we go adding judges, let's fill the vacancies that we have first.
All right, thank you. Ms. Spotteswood, the incident that you told us about that gave rise to the pictures that you have submitted into the record, that incident took place beyond the shores of America. Is that not correct?
That's right. And multiple times that I was assaulted, it was on international trips.
Probably to keep you from being able to file a criminal action against Mr. Christie, correct?
Perhaps.
Yeah. And Professor Giles, we've got this nasty little thing called Amendment 7 to the Bill of Rights. Can you talk to us about how important the Seventh Amendment is to the freedoms that were guaranteed to individuals under the Bill of Rights?
I can. The Seventh Amendment right is so fundamental, and I teach law school, and right now I'm teaching civil procedure for those of you who went to law school. And in civil procedure, our entire course really focuses on this moment when we're going to get to a jury, right? We talk about the pleadings and discovery and all the pretrial process, but the idea is that the jury is going to be the final determiner. Now, very few cases end up in juries anymore, less than 2% by recent numbers, and Representative Jordan mentioned how few cases get to a jury, but that is still our idealized vision of justice. And so the idea that one would waive the right, the Seventh Amendment right, in a contract where you're not even paying attention to the things you're signing, you're not reading the fine print, you're not understanding the fine print. And I think despite these discussions about disclosures or disclaimers, none of that's going to do any good, because frankly, when you first get a job and you get that packet of material, you're so excited to start your job. I mean, I'd sign just about anything because that's the job I want.
And that's
right?
why we call it forced arbitration.
That's why we call it forced arbitration. And no disclaimer in the world will sufficiently make me worried about the rights that I'm giving up, because I'm at the beginning of the relationship. I'm not thinking about the end of the relationship yet, right?
There's a power disparity
Yeah.
between the employer and the prospective employee when it comes to the papers that need to be signed. Does
Yeah.
the employee actually have a choice?
No choice at all. That is why we call it forced arbitration.
And that arbitration process you talked about being so secret, and we've heard questions or insinuations that locations for arbitration proceedings are not secret. Can you shed a little light on that?
I can't, because they are secret, so I can't shed any light on it.
There's no notice?
There is no notice. They're not publicly docketed, Representative Johnson. We have no idea where they take place.
The
We
public
assume,
doesn't have a
no,
opportunity
the
to
public, the
come in.
press, none of these documents is available for any publicity. And as
How, and let me
Yeah,
interrupt
sorry.
you here. How does this secrecy play into the serial offenders, the predators that keep doing this time after time? How does secrecy enable them to do that?
Because it enables employers to shield them from any publicity, right? It keeps them on, right? They're still CEOs of companies. They're still heads of Fox News for years and years and years, and they engage in this activity. They're serial sexual predators in the workplace. And because each arbitration is private, nobody knows about the past issue. And so new women join these companies and they have no idea what's been going on. And it takes a lot for these women to finally come forward, as we're seeing today.
So many broken lives, but you ladies who have appeared today have shared your life story with us, bravery, tenacity, survival. You are wonderful people. I'm sorry that you went through what you had to go through, but I appreciate you all coming and sharing your story with us today so that everyone can hear. Thank you. I yield back, Mr. Chairman.
Gentleman yields back, Mr. Issa.
Thank you, Mr. Chairman. I'm going to start off with a question. Hopefully I can get a hand raise if it's a yes. Would all 5 of 6, including our remote visitor, witness, would all 6 of you agree, I'm sorry, I got my count right, 7 of you, would all 7 of you agree that in fact, if non-disclosures were taken out of the binding arbitration process in the case of assaults, that this would be an improvement in the status quo? Those who agree, raise your hand. Okay, I'll get 3 out of 7. So let me just ask you, now yours is a case of a criminal attack outside the United States, and you were not bound by a non-disclosure because you didn't go through the process, is that correct?
I had a non-disclosure in my original employment contract.
Did you go through binding arbitration?
Yes.
And at the end of binding arbitration, they compensated you for this wrongdoing in some way, and you thus were bound by a non-disclosure?
I was bound by a non-disclosure before I even got to arbitration, and I was compensated for, because I won my arbitration, which is so unusual because it's so hard.
So I just want to go through, why is it you think that taking that out wouldn't be an improvement? I didn't see your hand rise.
Because secrecy isn't the only problem with forced
No,
arbitration.
but
it's also very unfair.
That isn't the question. I understand you want more.
Yeah.
But I want to get an answer to, I think, a critical part of the deliberative process here. I've been hearing, and I think accurately, and I'm going to ask you one more time, because, I mean, a victim is the best person to ask to a great extent. If you had been able to tell your story, not bound by a non-disclosure, would that have been better than being bound by one? That was the only question. Not does it make the system perfect, but would it be an improvement?
It just sounds like I'm being offered a half measure, and the forced arbitration is so unfair.
So I understand you think forced arbitration is unfair. That's great. Most of the people on that side want to eliminate it for everything, not just situations.
Will the gentleman yield for a question?
I will not. The reality is your side's been running over by a minute, and I won't be given that same opportunity. So down to our 2 witnesses on the left here. You raised your hand and said yes, that getting rid of that would be helpful. In a sense, doesn't that eliminate what we heard in testimony as to the actual injury? Wasn't almost every one of our witnesses was talking about the effects of secrecy, not the effects of the actual binding arbitration? Please.
Congressman, I would agree with you. I do believe if we are going to institute piecemeal separations of particular claims in arbitration, which, as you rightly noted, is just another attempt to try to eviscerate the FAA, which for 30 years has been upheld by the Supreme Court as being as good as litigation, even including discrimination claims. In this particular instance, if we are talking about sexual assault and sexual harassment, and confidentiality is the primary concern, I would think language like that would solve the problem.
That's what I heard, and that's why I was asking. Additionally, when I read the legislation we'll be considering tomorrow, it puts a definition of sexual harassment. Is there a definition similar to this, as far as you know, in the statute today that defines sexual harassment in the way this one is defining it?
No. There is not.
Okay, so this would be not just about arbitration. This would be a new law that defines sexual harassment, at least in the workplace, in a brand new way with a single hearing.
Correct.
Okay, the second one is a big one for me, and it hasn't been talked about here today. Under HIPAA, you can't talk about something that happens to somebody medically. But if someone is raped, you can report it as a crime. As a matter of fact, if you're a healthcare professional, you're required to. Should we, with this power, in fact, make it to where the arbitrator or anyone else who becomes aware of the allegation of a crime, which is credible, be required to report it? And would that, too, eliminate some of what I think we heard today validly as a problem of binding arbitration?
Absolutely. Arbitrators are supposed to implicitly and explicitly protect the privacy of negotiations, but when a crime has been committed, they absolutely ought to have to report it.
Well, our witness alleged a crime. Was that arbitrator wrong in not reporting that crime?
Absolutely.
Okay, thank you, Mr. Chairman. I yield back.
The gentleman yields back. Mr. Cicilline is recognized.
Thank you, Mr. Chairman, and I want to begin by just thanking the 4 survivors who have come forward to share their stories to this committee and to the country. I know this is not easy, but I hope you know that your testimony will help us solve this problem by moving forward with legislation to fix this problem. So hearing those experiences was painful to listen to. I can't even begin to imagine what it was like to experience them, and they were horrific, and I am in awe of your courage, all of you, for being here today and sharing your story, so thank you for that. I want to first just ask a yes or no question. Ms. Parshall-Perry made it sound like these forced arbitration clauses are so great, everyone just wants them. You know, people, of course, if that were true, they wouldn't be called forced arbitration, they wouldn't be hidden in an employment contract, and you would all know about it, and you'd be asking for them. But of course, that's not the truth at all. So my question for each of the survivors is, did your employer at any time when you were hired point out to you what was contained in your contract with respect to forced arbitration? You could just answer yes or no.
No.
Ms. Newton?
No.
Ms. Henry?
No.
And Ms. Dushku?
No.
So in each of these cases, you had employment contracts that had provisions that you didn't, the employer made no effort to have you understand you were actually giving up this very important right to have any claims heard. And I'd like to begin, Ms. Dushku, with you. If you could just speak a little bit about what the effects of your experience were, your inability to speak about what had happened to you. How did that play out on the set where you worked? And how did it affect you in your life, both in your profession and just in your personal life?
I would say that, the saying sunlight is the best disinfectant, and the inability to name something sort of increases, the gaslighting around, did this happen? Is this appropriate? Was this not appropriate? Taking away our ability to share with our peers or our, team or the systems and the people that are supposed to be protecting us. And as I've learned from my own experience and even in my graduate studies around trauma and healing, there's original, we're as sick as our secrets, as the saying also goes. There's the original offense of the crime, but then to add the silencing on top of it, it kills your spirit, and it takes your dignity. And as I've said, as somebody who's been known to be outspoken and speak up for others and in the face of adversity, I can't describe what the last 4 years have felt like, to get nervous to go to a family dinner and speak to one of my own siblings about what I had experienced. The silencing keeps us sick as individuals and as a society and as in our overall culture.
Thank you. Ms. Newton, you described how members of the legal team at Louis Vuitton, including your direct supervisor and the general counsel, attempted to really brush aside your reports of the sexual harassment that you experienced. And do you think that contributed to the culture where sexual harassment is allowed to flourish and victims are silenced? And what role do you believe that arbitration clauses, what role do they play in terms of individuals not knowing they're going to be held accountable in any meaningful way?
Right, so when I first went to my colleague, because I'm part of the legal team myself, and told him about what was happening, it was first ignored. And then later, when I became insistent about it, I was told, well, I'm not HR, so I can't report this. When things escalated and I filed a written report and I told my boss, the general counsel, this isn't being handled properly and it needs to be. She asked me, have I done something to wrong you? In other words, I was reporting this in order to bother her. It was a bother, it was a disturbance. So that, if I, as an attorney within this company, was basically shunned, dismissed at every single turn, and basically told, you're a nuisance to us by raising these claims of sexual harassment. I can't imagine what the marketing manager goes through, the intern goes through, someone else, So it creates this culture of, don't bring this to us, we don't want to hear it, we don't want to deal with it.
Thank you. And I just want to say in closing, the suggestion that we should wait until these incidents rise to the level of crime so that people can just report the crime as if that's a solution. There's an enormous amount of behavior at issue here, which may not, in fact, rise to a level of a crime that women and all individuals should be protected against in the workplace. This is despicable behavior, and to the extent that we allow individuals responsible for this conduct to get away with it by these forced arbitration clauses, we should be ashamed of ourselves, and we're going to fix that tomorrow. With that, Mr. Chairman, I yield back.
The gentleman yields back. Mr. Gates.
Thank you, Mr. Chairman. Ms. Parshall-Perry, you mentioned in your testimony that it was the progressive leadership in the House and the Senate that's pursuing these changes to arbitration. I would just note for the record, they aren't alone. No one has confused me for a progressive, and I'm a proud Republican lead on Mr. Johnson's good legislation to reform these practices. And I don't think this is a lens that we should evaluate through a traditional political ideology. You did cite some data that I wanted to delve into. You said that in arbitration, the amounts awarded were double that of the traditional litigation process. What is that study?
Excuse me, that's a study by NDP Analytics, and they approached an analysis of 100,000 cases, and that was a study that was done
And in the, did it
in
also
2004.
Did it analyze win rate or just the amount awarded?
I don't know. I'd have to go back and look at the study.
I think it could be misleading to cite just the amount awarded in absence of looking at the win rate. And so I did a little research on that subject that postdates the research you've cited. And Mr. Chairman, I seek unanimous consent to enter into the record a study by the Economic Policy Institute, December 7, 2015, entitled The Arbitration Epidemic.
Without objection.
And I'll just use my time to analyze that point of win rates. This is quoting from the study. Employee win rates in mandatory arbitration are much lower than in either federal court or state court, with employees in mandatory arbitration winning only about a fifth of the time, which is 59% as often as in federal courts and only 38% as often as in state courts. Differences in damages awarded are even greater, with the median typical award in mandatory arbitration being only 21% of the median award in federal courts and 43% of the median award in state courts. The most comprehensive comparison comes when we look at the mean or average amount recovered in damages across all cases, including those in which the employee loses and zero damages are awarded. When we make this comparison, we find that the average outcome in mandatory arbitration is only 16% of that in federal courts and 7% of that in state courts. Mandatory arbitration is massively less favorable to employees than are the courts. Are you persuaded that this evidence that postdates your study might inform on that analysis?
It may. I am aware of the EPI study. That was a 2018 study. I am also aware that there are connections between trial lawyers and the plaintiff's bar and EPI, who are themselves incentivized to make sure that cases are brought to litigation.
Very important point. Are there any connections between NDP Analytics and the business community?
There may be.
Okay, so I think we'd have to acknowledge that. Eliza, I wanted to turn my remaining time to you. I heard a colleague share with me a story of someone coming to them who took a job that was also an on-camera job, and that person was harassed and forced into arbitration and had a negative consequence there. It was deprived of their day in court. And my colleague in Congress asked that person who visited with them, would you have done it again? Would you have taken the job, and would you have signed that mandatory arbitration clause knowing what could happen? And upon reflection, that woman said to my colleague, you know what? I wanted the job so bad. I craved this opportunity. It was my break in life. Even though I was mistreated, even though I was harassed and abused, I'd probably do it again. And hearing that was heartbreaking to me, that in our country, we would create conditions that force anyone into a circumstance like that. Looking at the opportunity you had, that most people would do just about anything on the planet Earth for, would you do it again?
No, I can't unknow what I now have come to know. And so as far as my career since then, I've chosen not to act professionally or in any other way because I would never sign away my rights again. And my understanding is that these provisions are part of most Hollywood contracts at every major studio. They're a take it or leave it deal. And there's no price for my dignity and my rights. So that's been my.
I really appreciate that perspective, but it just seems like such an abhorrent choice to put to anyone in the American workforce. You basically have to accept this contract of adhesion, or you have to deprive yourself of the most meaningful contribution you can make to the workforce and to the country. I thank the chairman, and I yield back.
The gentleman yields back, Ms. Bass.
Thank you, Mr. Chairman. And let me just take a minute to thank the witnesses for being here. I can only imagine how difficult it is for you to share your stories, but just want you to know how important it is that you've had your day, but also to educate us. I wanted to ask Professor Gillis several questions. I wanted to know if she could explain how the power dynamic between a prospective employer and an employee affect the validity of the arbitration clause in an employment contract. Put another way, what makes it forced? One more question to you. Many Americans don't know what arbitration is, and many litigants have no idea they've signed an arbitration clause. How does this use of fine print and opaque wording add to the coercive nature of many employment arbitrations?
Thank you. I'm happy to answer those questions. So first, on the power dynamics, which we've talked about a little bit already at today's hearing, I think, and frankly, Representative Gates just put it really well. I think the truth is that we want the job, we want the opportunity so badly that we are willing to sign away a lot of things in order to have that opportunity, and to assume at the start of a relationship that everything will go pretty well. So I think the power dynamic exists. I think it's a structural imbalance that is always true in employment, and I think employers are taking advantage of that structural imbalance by forcing their employees into arbitration. And on your second question, which is very related, I don't know if you've read an arbitration clause. I will try to send one so that you all have one in the record. They are incredibly opaque. Even as a lawyer, I read them and I have to reread them and reread them again to understand exactly what it is they're trying to do. But maybe employers shouldn't be blamed for how opaque they are, because after all, what they're trying to do is rewrite an entire procedural system because they're foregoing the procedural system that we've already established in our courts. And doing that takes a whole lot of time and energy, especially if you're just trying to maximize your interests. And so these are really opaque and difficult to read. They often take pages and pages to describe. And I think most people don't read them, or certainly don't understand them if they try to read them. So all of this is, I think, part of the problem.
Well, actually, can you take a few minutes to walk us through the history of arbitration in employment contracts, and why has this practice been allowed to continue?
Thank you so much for that question, because I've been hearing things today that, that are making my blood boil a little bit. The FAA was enacted in 1925, but it was enacted so that sophisticated business people could negotiate for arbitration provisions, and those provisions would be respected by courts. It was never intended to be imposed via standard form contract. And in fact, if you read the legislative history, if you read the legislation, it accepts and exempts employees. So the idea that the FAA applies to employees is something that was created by a conservative majority of the Supreme Court in 1991 in a case called Circuit City. I'm sorry, first actually was Gilmer and then Circuit City. I can't keep all the bad cases straight. And those are the cases in which the court interpreted, I would say misinterpreted the FAA to apply to employees like this. So that now employers can just stick these clauses into job applications, orientation materials, even an innocuous email from HR can include a forced arbitration clause. That was not what the 1925 Congress intended. They should be rolling in their graves. This is not what they intended. This is what a Supreme Court intent on protecting corporations intended beginning in the 1990s. So all I can tell you, Representative, is that from the 1990s till now, we've just had worse and worse opinions. In 2018, the Supreme Court decided a case called Epic Systems, where it basically threw the NLRA under the bus and said that the FAA is more important than the right to collective action under the National Labor Relations Act. A term later in Lamps Plus versus Varela, the court helped out an employer who apparently couldn't write a cogent arbitration clause and sort of said, hey, we got what you meant. You meant that your employees can't bring class actions. We'll help you out there, and basically rewrote the agreement. They will do anything, this 5-member majority of the Supreme Court, to enforce these arbitration clauses because it protects big business. But I think that that's not what this body should be doing. This body should be protecting these women and other women like them. Thank you.
Thank you. My time's expired.
The gentlelady's time's expired. At this time, the committee will take a very brief 5-minute recess.
Yeah, we're good.
The committee will come to order. At this time, I recognize Mr. Biggs for 5 minutes.
Thank you, Mr. Chairman. Appreciate every one of our witnesses being here today. And for some of you, it just can't be a really easy experience, and appreciate your willingness to be here and share your experiences with us. I'm sincerely trying to understand this bill and whether it's the appropriate measure or whether it could be better, or how to design it. And so my questions are meant sincerely, trying to get a handle on this. I was a litigator, and I tried lots and lots and lots of cases, and everything from arbitration to jury trials at every level. And so I have a lot of experience in these areas, and so I've broken this down in my own mind, and I think Mr. Isa was trying to get there, but I'm trying to make sure I understand it. There's three aspects of this bill that I think are interesting to me. Number one is the nature of arbitration in and of itself. My experience as an arbitrator was it's a very small sample size, but it was very unsatisfactory as an arbitrator. There was pressure on me as an arbitrator from the side that appointed me, and that was very, very uncomfortable for me. But on other cases where I was the attorney representing a plaintiff before the arbitrator, and in some cases it was quick, it was short, it was easier, it was faster, and our reward was better than we had anticipated. So the question, of course, is the arbitration itself. Is that really the issue? The forced aspect of this, the contract of adhesion aspect, that seems to be a huge problem here. I'm a big advocate for, I hate to be forced to do anything, and I hate for people to be forced to do things. So this contract of adhesion type of aspect is really disturbing to me. And yet at the same time, I'm a big believer that people should be allowed to enter into contracts, but I also understand there's a power discrepancy. So we're trying to resolve that issue here as well. And then the third thing for me is the transparency or lack of transparency, or the non-disclosure, or the secretive nature of these types of arbitrations. And so I think Mr. Isa was trying to get at, and I don't want to steal what he was doing, is this notion of if you had transparency, if this were open and notorious and you could bring it forward, would that resolve some of the problems? I think you all said yes. I think Professor Gillis, I think you indicated that might be helpful in some. You did not. You don't think transparency would be?
I think that the issue is that you're trying to fix a system by making it as close to court as possible, and I guess I'm wondering why don't we just let these women go to court? I don't understand. Yeah.
Don't get ahead of me. I'm trying to understand the three components I've raised here.
Right.
So.
But you're saying that if we could make everything transparent, so maybe if you could tell me.
No, I'm not saying that. What I'm saying is, would transparency improve?
Transparency of what? Why don't we try to.
The arbitration itself.
The entire thing. So from the filing of the complaint, through the arbitration, through the award, the appellate process, and the confirmation in court. All of it should be transparent.
Right.
Okay, then I just have to ask you respectively, then what's the difference between that and court?
First of all, the difference is, I'm sure you've litigated cases. It's huge.
Okay, you know, the thing is.
A case in an Article 3 court can take boundless amounts of time, boundless amounts of discovery. You have discovery in arbitration, but it moves so much quicker. It really does. That's been my experience. And so when I'm talking about transparency, and you're saying, well, you're building a whole new system, that whole new system's been in place for 100 years.
It's been in place for 100 years for big, commercial, sophisticated companies. When you were an attorney arbitrating your case, representative, just answer me this. Weren't you representing a company arbitrating against another company? Oh, really? An individual?
Absolutely. Yes, absolutely. Individuals against individuals.
In my home state, that's not an unusual thing.
Can
So
I ask-
that's my point. That's my point is your, and now, dang, we've taken too much time just getting to that. I'm just trying to understand bit and bit how we can improve a system so we protect victims, because no one should have to make the decision. I agree with Representative Gates. Nobody should have to make the decision about whether you're going to be compelled to find a certain dispute resolution or take the job of your dreams. I mean that really is what I'm trying to get at, and I think there was some kind of defensiveness on your part, and it's unfortunate because I really wanted to understand the transparency part and lack of it. I'll have to yield back because my time's up.
Gentleman yields back. Mr. Cohen.
Thank you, Mr. Chairman, and I appreciate your holding this hearing today. I'm sorry I was late, but my car did not start. It does that on occasion. I thank you and all the witnesses for being here and testifying for the committee, some with some personal difficulty, but I appreciate your willingness to come forth and put color on this issue. It's truly sad that we have to even have a hearing. Arbitration is an issue that has come before this committee in other instances, and I'm against forced arbitration, but I can understand it in certain issues. But when you have forced arbitration, where you have to deal with forced actions by your employer on you, and then you have forced arbitration, that's what they call a hat on a hat. You don't do a hat on a hat. It's doubly bad. So I appreciate your being here. Today's witnesses and countless others have been sexually harassed or violated by people who thought they could get away with it because they were the boss. The boss gets whatever the boss wants. And especially if they have forced arbitration, they know about it. Sometimes you don't, because you don't get into the contract. You want the job. You don't get into the nitty-gritty and the details and understand it. And you have no choice. It's an adhesion contract. You get the job or you don't. So you take it and you expect you're not going to have that kind of conduct anyway, so it's no big deal. But then you have the conduct. They know they've got the forced arbitration. And so they feel comfortable harassing you because they know that they've got this forced arbitration and they're going to come out the winner. They got the deck is stacked in their favor. Professor, is it Giles? Gillis? Gillis, okay. The structure of forced arbitration allows perpetrators to operate this way. Could you walk through the preliminary differences between the traditional legal system? You might have already done this while I was under my hood, and forced arbitration.
I'm sorry, I didn't hear the question, sorry.
I say, the primary difference between the traditional legal system?
Oh, I see. Yeah, totally fine. So in a traditional legal system, I go to court and I file a complaint, which is immediately publicly docketed, meaning I can search for it. It is a public document that other people in my workplace can read and learn about the allegations that I've made against an attacker, a perpetrator, or the employer. All subsequent briefings and other filings are publicly docketed. The hearings before the court are, the public is welcome. The press is welcome. And that kind of transparency, I think Eliza called it, sunshine is the best disinfectant. I think that's what our legal system is based on. We don't have many closed-door judicial proceedings because we believe that the best way to get justice is to make sure that everybody is watching. And I think in this space in particular, people have to be watching. Employers have to know that there will be consequences if they don't deal with toxic corporate culture.
And in forced arbitration, it's not necessarily in the open. It's private.
It's private.
Kept under covers.
Right, yep.
Protects the violator.
No written decisions. Arbitrators are not able to offer relief beyond, to deal with structural or pervasive problems.
How has this structure impacted the success or lack of success of claims brought by victims of sexual assault?
Well, first of all, the structure almost guarantees that very few victims will ever come forward. I think we're seeing a few very, very brave women who are able to come forward and go through arbitration, but because you have to arbitrate individually and because you have to play by the rules that the employer has written, lots of people feel like the game is rigged before they even start.
Right. Who picks the arbitrator? I mean, are the arbitrators generally folks that have a record of being favorable toward business?
Well,
employers?
so, just to disaggregate the question a little bit, the employer pre-designates the arbitration provider, say the American Association of Arbitration or JAMS or some other group, and then the entities may pick the arbitrator. But here's the problem. If I'm an individual employee trying to arbitrate against my employer, I don't know who those arbitrators are. I get a list of names, I don't know who they are, whereas the employer definitely knows who they are because they are repeat players in the system.
Somehow it works out, it's according to my information, that in the last 5 years, only 1.9% of victims have won their arbitration cases against their employer.
Yes.
That's worse than Congress getting its subpoenas enforced against the Trump administration. It's bad numbers. It's just amazing to me that we even have to have this hearing, that it shouldn't be permitted and in these type of cases because the person uses their power to try to bring pressure to get sexually harassed or sexually assault, and then they get to have a system that's in their favor where it's a 50-to-1 shot to win. It's absurd. Thank you all for testifying. I appreciate it. I yield back the balance of my time.
The gentleman yields back, Mr. Raskin.
Thank you very much, Mr. Chairman. In the United States, in the 21st century, the power that you have as a private boss does not include the right to sexually harass or stalk or grope or molest or rape your female employees. A private corporation is not a royal monarchy. It's not a totalitarian government. It's not a mafia state. A private corporation exists because it gets a charter from the state. It's governed by the Constitution of the United States and by federal law, including Title VII, which defines sexual harassment as sex discrimination, illegal sex discrimination. These four citizens of quite breathtaking strength and courage have just ripped the mask off the continuing regime of sexual harassment and sexual assault by male bosses in certain corporate workplaces who operate with impunity and brazen contempt for the rule of law in our country. This regime is made possible by the pervasive corporate nullification of a constitutional right, specifically the Seventh Amendment, which states that the right of trial by jury shall be preserved. I'd like to ask our witnesses whether you think you lost something by the destruction of the constitutional right of jury trial and what you think might have happened if you had gotten a jury trial. And I wonder if you could just speak briefly, because I have one other thing I need to ask Ms. Newton. So, Ms. Spotteswood.
I absolutely feel like I lost something. A jury of my peers, full discovery, production of witnesses who weren't able to, who my employer didn't produce, and just having the rules of civil procedure, which were designed to protect people like me.
Well, what an excellent answer. Thank you.
Thank you.
Ms. Newton, I'm going to come back to you in a second. Ms. Henry.
Yes, it angers me that somebody in this position, Mike Gentry, who never has to go in front of a jury, explain his actions and why he did what he did, or even, I feel like I'm not getting, it's not fair to me as the victim. Yes, I would like to see someone like this have to go in front of a jury.
Do you think there's some wisdom in what the framers of our Constitution put in our Constitution?
Absolutely.
Thank you very much. And Ms. Dushku, what about you?
Thank you. Again, I think accountability and transparency. The people who harass and assault have to become accountable to the public, to others aside from just those who are involved in the case. And that's accountability, I think, is the only thing that changes behavior.
Awesome, thank you. Now, Ms. Newton, you got glowing accolades and perfect evaluations from your boss, who was the general counsel of Louis Vuitton. And he wrote that you reflect the highest degree of honesty and ethics in all that you do, and that you achieve excellent results, and that you are a client's dream. You were promoted to Vice President of Legal Affairs, is that right?
Yes, that's correct.
Okay, then you were sexually harassed in the most grotesque and terrifying ways, and when you reported it, you suddenly became the victim of what you call a campaign of retaliation and intimidation by the company, which was insulated by the forced arbitration agreement and felt it could cover up everything. Now, amazingly, if I'm reading your testimony right, you are being sued for their attorney fees. And let me just see if I can recap this. Tell me if I get it wrong. But they moved to compel arbitration. You defended against that based on the New York state law, which said that those forced arbitration agreements are no good in New York law. You won at the district court level, but then the appeals court essentially changed the result by saying it's not retroactive to cases of sexual harassment that took place before the state legislature acted. Now they're coming after you for attorney's fees. This $330 billion company with $60 billion in annual profits, whose employees subjected you to really vicious sexual harassment and assault, they want you to pay them how much money?
I don't know the exact amount, but I presume it's about $500,000.
Hundreds of thousands of dollars they're looking for. And amazing to me that along the way, Louis Vuitton tried to displace responsibility that they have as a corporation operating in New York State, in the United States, by saying that there was a difference between American and French culture, which is a great insult to the French, especially because your harasser was American, right?
Yes, and when I worked in France, I was never sexually harassed or assaulted in France.
They are just adding insult to injury at every turn here. I would hope that they're not stating that that's French culture, because I know sexual harassment is against the law in France as well. I want to thank Mr. Gates for supporting the legislation against forced arbitration. This is not a partisan problem. The divide here is between those who think that corporate contracts can override the Constitution of the United States and federal law, and those of us who want to stand up for every citizen's right to go to work in dignity, free from assault and harassment. So I support this legislation very strongly. I want to thank these remarkable witnesses for their courage. It's amazing to me that two of you are lawyers, which I think just reflects the extent of this problem of forced arbitration agreements stuck into these contracts. And if anybody might have caught it and been able to stop it, it would have been lawyers, and you were not able to, and you guys speak for hundreds of thousands or millions of women, and indeed some men across the country. I yield back.
The gentleman yields back. Ms. Jayapal.
Thank you, Mr. Chairman. I want to just start by saying thank you so much to Ms. Spotteswood, to Ms. Newton, and Ms. Henry for your testimony and for giving courage to millions of women across this country. I know this isn't easy, and I'm sorry that this is what you have to go through. I am a very proud co-lead of this bill, the bipartisan, bicameral legislation, the Ending Forced Arbitration for Sexual Assault and Sexual Harassment Act, which would preserve the right for sexual assault and harassment survivors to choose how they seek justice. So you have my deepest, deepest appreciation. Ms. Spotteswood, I'm very grateful for your testimony, and I'm going to direct my questions at you, and I am sorry to have to get into the details of this in the way that I am going to, but I think it's important for the country to hear your voice and to see your courage and to see what you had to deal with. When Chisti sent you an email about him fantasizing about raping and strangling you, how did you react, and how did you feel about your safety?
Thank you. I was appalled. I felt very unsafe. I was really afraid for my life and my well-being. I didn't think there was anyone I could go to because I had already spoken to the head of my office and asked other people on work trips to keep an eye out for me, and I just knew that nobody was going to intervene, and so I felt very alone.
And that event occurred before the company trip to Brazil, correct?
Which event? Sorry.
When you got the email, that occurred
yes.
before your company trip to Brazil. And you were responsible for the Brazil account. So it's fair to say that you had to go to Brazil, correct?
I was the head data analyst on the accounts, so yes, so I had to go.
That was your job?
Yes.
That was your job. Do you believe that Chisti planned in advance to strangle, beat, and rape you in Brazil?
I try not to think about what he was thinking, but yes, I would imagine so.
And when you were on the Brazil trip, after you told Chisty that you were feeling unwell and heading to your room, what was your reaction when he said he was, quote, coming to your room?
I just felt like I had run out of options. And at that point, I was trying to mitigate harm and not make him any angrier. If he was going to be showing up at my door angry because I hadn't responded, that seemed worse. Then, yeah, so I wanted to get, I wanted to not get hurt.
You believed that he would have forced his way into your room?
I didn't know what would happen.
And you felt that you would face even greater harm or injury if you had not gone there?
Definitely.
It sounds like you were in survival mode at this point. Were you afraid that Chisty might try to kill you, especially if you continued to ignore or resist him?
I was. I wouldn't necessarily have put it that way at the time, but I was having nightmares even before my experience in Brazil. Yeah, panic attacks. And I think a lot of us are very good at compartmentalizing because I wanted to do my job. I wanted to be really good at my job. And so I tried to put it away, but those things kind of rise to the surface from, in your subconscious. So, yeah, I was very afraid.
And the attack occurred overseas. Did you feel comfortable going to the Brazilian police, and would the law even have allowed you to seek help from American police?
I did not feel comfortable going to the Brazilian police. It's not common for people to speak English there, and I was afraid of what would happen if I went to that authority there. When I came back to the US and consulted an attorney, they said that they thought that it was unlikely that criminal proceedings could be brought because the events had occurred abroad. So, so I didn't really consider that an option.
And Ms. Spotteswood, your abuser went to great lengths to remove you from the country and away from your friends and family before forcing himself on you, and he repeatedly asked you for sex and put you in a position where you had to speak up to get him to stop. Did you feel that you had to apologize for repeatedly turning him down? And how did his repeated advances in anger at your rejection affect your behavior?
Absolutely. So, yeah, I think anyone who has experienced something like this knows that you don't just say the same thing every time someone asks you like this, because you try to say something else and convince them another way. And I didn't want to just repeatedly reject him in a way that would make him really angry, so I would come up with other reasons. Like I would tell him that I, had work and couldn't meet up, or would just basically would just say anything else to get out of the situation. And I think women who are having these kinds of experiences just never think that anyone's going to be looking at a transcript and try to figure out what happened. So they're just doing whatever they can to try to get through an experience without getting hurt.
To survive. Ms. Spotteswood, nobody should have to go through this. I am so grateful to you for your courage, for your bravery, and your testimony. Forced arbitration for sexual assault and harassment is a lose-lose scenario, and we are going to do everything we can to pass this bill and to protect women like all three of you and millions around the country who are grateful to you today for your courage. Thank you so much. I yield back, Mr. Chairman.
Thank you so much.
The gentlelady yields back. Ms. Demings.
Thank you so much, Mr. Chairman, and thank you to our witnesses for being here today. As someone who worked in the criminal justice system, I think the testimony that I have heard today, what has happened to you, is appalling. And our job is to make sure that it doesn't happen to other women. I don't know if there's anyone who believes that forced arbitration should be okay. in cases of sexual harassment and sexual assault. And you know, as I listen to each of you testify today, there just seems like there is this recurring theme that it's almost a culture. It's, you know, an incident that occurs. Okay, let's deal with, I wish this was an isolated incident, but it seems like it's a culture where powerful people in powerful places believes that everything and everyone is on the table, and through forced arbitration, they almost in advance get the victim's permission. Ms. Gillis, if you could speak a little bit about the culture, that's what really bothers me about this, the culture of it. Because when something bad becomes so acceptable, and if you could, Ms. Gillis, just talk about the culture. And before you, Ms. Spotteswood, you talked about how you were victimized in front of your coworkers. Like the culture, it was okay to let everybody see because that's what happens here. And to say that it's okay to just settle for forced arbitration, I think it's appalling. So Ms. Gillis, okay, please.
I think you've hit it right on the head. I think forced arbitration allows employers to maintain a toxic culture. People are getting promoted, right? Ms. Newton tells us a story about people getting promoted, her attacker getting promoted. These sorts of things, you know, people grabbing butts in front of people, this kind of thing is a culture. And let's be clear, there's only one way to break down a toxic culture, and that's sunlight. We have to make it transparent what's happening. We have to make companies realize that there is accountability and possibly liability if they fail to fix the culture. We can appeal to companies in all sorts of ways, and I know you all have tried to do this. It's not in their economic best interest to allow these things to go on. They lose money when women are not productive, when women are afraid for their personal safety. They lose time and productivity when men are just, you know, doing these crazy things. We can appeal to that, and it does not change the culture. What changes the culture is accountability. That's why we have courts, not arbitration. That's why we have courts, and they have done a very good job, not good enough, right, where these things are still happening, but I think we've gone back. I mean, I think when you think about it, and I'm old enough to know this, we've gone back to like the 1980s in the way that corporate culture is allowed to just be, you know, bros, just people doing whatever they want.
Ms. Spotteswood, as we're talking about the culture, and I just so appreciate all of you for being here today to shine a light on this problem in our society. Tell me about, you know, I don't necessarily want to ask you how you felt, but to do it in front of others, just like it was expected, it was okay. Could you talk a little bit about that moment, please?
Of course, it was humiliating. I felt like an object you never want your coworkers to be thinking about your butt or thinking about you as sexual in any way. And that's what this does, is it forces you to be a sexual object in your workplace. And it's someone else making that decision for you, and you never get to take that back from them.
Thank you so much. And finally, Ms. Henry, you talked about during your time, and you were so glad all of you were so glad for the opportunity in your dream jobs, but you were told it was just HR stuff, right? It was just HR stuff that when you were signing the papers. And we know that closed arbitration is often buried in the fine print. If it's such a good thing, such a great option, why do you believe it's buried in the fine print and it was just told to you it's just HR stuff?
I feel because they don't want you to know. They don't want anybody, I guess, to be held accountable for such actions. It's easier just to sweep it under the rug and let it go, and then try to make, you know, nobody in the community knows. Customers coming in daily doesn't know what's happening behind the scenes. It's not fair to Again, it's not fair to the victims. I had no idea what even arbitration was until I came here.
Thank you again. Thank you all so very much for your testimony today and your bravery. Thank you. Mr. Chairman, I yield back.
Gentlelady yields back. Ms. Fischbach?
Thank you, Mr. Chair. I appreciate the opportunity. And I just want to direct, some comments to Ms. Perry and Ms. St. John. And, what's happened to so many women and others in the workplace is terrible. But I really am concerned that by involving the government in these contracts between adults in the area of sexual harassment and assault, we're opening a door for more government involvement in other areas of contracts. And I think, Ms. Perry, in your opening, you pointed out some of the things that are going on already. There's over a dozen bills right now in the House which have government intervene in contracts. Clearly, this bill is not being considered in a vacuum. There is a lot going on with this. There's a concerted effort in Washington, D.C. to decide the contents of contracts between adults. This is not what the competent and responsible adults of my district want, because they accept the fact that they're signing a contract. But Ms. Perry, do you think there's a danger in passing small targeted bills like this one in opening the floodgates to government intervention in contracts? If you could speak to that.
I absolutely do. And in fact, the reason that I've mentioned confidentiality and NDA agreements and needing to make clear that if this bill goes forward, it needs a rider discussing things like the inapplicability of NDAs. That would be a protection, but what we've done is we've already cracked a hole in the dam to eviscerate whole cloth the FAA. I don't think there's anyone on this panel other than potentially Ms. St. John and myself who wants the FAA to stick around, and that's absolutely not even considering 100 years nearly of jurisprudence on the FAA and what the Supreme Court has time and again reinforced. In fact, they just granted cert in yet another case. They will take up arbitration again for the third time in 3 straight years. I do have problems when we come in and we make attempts to slice away certain provisions of longstanding federal law because it does open the door to more government intervention, and that does bother me.
And Ms. Perry, and Ms. St. John, if you have anything to add, please go ahead. But are any of the states addressing this? Is this just an issue at the federal level?
There are actually 5 states that have already passed legislation stating that in certain types of employment discrimination claims, NDAs, confidentiality agreements, cannot apply. So at the state levels, we are actually seeing an increase in legislation designed to be protective. And rightly so, these are contracts like any other contract, and there is absolutely nothing in Supreme Court history that says these particular contracts are coerced. In fact, the court has held universally exactly the opposite.
Well, and I would argue that you sign it. It is not, even though we use it's forced arbitration, as people are saying, it's not really, you have signed something that you have agreed to it. So, and just kind of a little bit, I guess, of a hypothetical, but under current law, what prevents someone from suing, even if there's an arbitration agreement in there, I understand that it could be thrown out, that there's issues like that, but I know that part of the issue is bringing things into the light, and even a case that was dismissed would certainly bring that into light, and there isn't anything that would prevent them from doing that.
Multiple federal circuits and the Supreme Court have vacated remedies, awards for material breach, for impartiality of arbitrators, for malfeasance, for imbalance of power, for adhesion. They will not enforce a contract that is deemed to be adhesive. So when Congressman Gates represented that these were contracts of adhesion are not legally enforceable.
Thank you very much. And I know there is one example that I've heard over time that even though there was an arbitration agreement in the contract, they sued the offender separately and were very successful in that. So, but is there anything else, Ms. Perry, that you'd like to add that maybe we've missed or you've heard that you'd like to add something to?
Well, we can quote battling statistics all day, but the fact of the matter is we have a 40% increase in federal filings. Our dockets are crowded. Justice delayed, particularly for women with these claims, is justice denied. That right to a trial, guaranteed by the 7th Amendment, has been interpreted by the Supreme Court to be as good in arbitration as through litigation with certain protections in place.
Thank you very much. I appreciate it. Anything, Ms. St. John, if you have anything you'd like to add?
I'll just add that there have been examples where workers have asked for these clauses to be taken out of contracts and they've been successful. And so the idea that it really is forced, I don't think is borne out by the facts.
All right, thank you very much, and Mr. Chair, I yield back.
Lady yields back. Ms. Scanlon.
Thank you, Chairman Nadler. And I want to thank all our witnesses for testifying before us today, particularly, obviously, the survivors. I applaud your courage and your openness in discussing this deeply emotional and painful subject. You know, like a majority of women in the workplace, I've experienced unwelcome sexual harassment and physical contact. While less horrific than the experiences you related today, I want to acknowledge how pervasive and corrosive this issue is, and thank you for your courage again and your resolution in sharing your experiences to really shine a light on what we're actually talking about here, not some dry contractual provisions. I'd like to discuss with Professor Gillis a couple different topics. The nuts and bolts of why forced arbitration doesn't favor employees, how it is different, what we're seeing today, than what Congress intended, and why it's a problem that the Supreme Court has so grossly expanded the Federal Arbitration Act. So first of all, the nuts and bolts of why forced arbitration doesn't favor employees. As several of our colleagues have mentioned, litigation is very expensive, but so is arbitration, isn't it? These employees have to get a lawyer. Sometimes the arbitration is in a venue that they're not familiar with. Can you speak a little bit to the costs of arbitration?
The costs are high when employees actually decide that they want to go into arbitration. They're doing it alone, right? So they're not doing it as a collective. So there's no pass the hat that we would see in a public court system because the arbitration clause prevents class and collective litigation. So right off the bat, I think that's a lot for an employee. And when you think about where these claims are coming from, they're often sounding in sexual harassment and hostile work environment. Proving that is a pretty huge lift, right? I mean, lawyers have a very difficult time, and we have some lawyers in the gallery who do this. These are really difficult cases. So I know there's been a lot said disparagingly about, you know, it's just going to be lots of plaintiffs' lawyers getting rich. Plaintiffs' lawyers don't get rich off of employment discrimination cases because they're really expensive, they're expert-heavy, and they require a lot of evidence. And the same is going to be true in a successful arbitration.
Am I correct that companies that include these forced arbitration clauses in the fine print in non-negotiable contracts are actually saving money, right? They don't include these clauses because it's the goodness of their hearts. It's a cost-saving ploy.
It sure is, and I just want to point out that Ms. St. John said earlier that having these clauses leaves money for companies to add to benefits of employees, and I tried not to laugh out loud because that is not what's happening, okay? It's not like my 401k plan is getting better matched because my employer has a forced arb clause. They're keeping this money, they're saving all the money that they would spend on litigation or spend on just making their work culture safer for women, and they're just using that to line the pockets of their shareholders.
So we've seen a little bit when the Forced Arbitration Act was originally passed in 1925. It was designed, as I understand it, to be an option for commercial entities of roughly equal bargaining power. And in 67, the Supreme Court even held that it was designed to include protections for captive customers and employees who don't have equal bargaining power and are faced with a take-it-or-leave-it contract. But what we've seen over time is that the Supreme Court has expanded the FAA beyond Congress's original intent, so that it does apply to everyday consumer and employment contracts. This seems like it should be an opportunity for Congress to intervene and say, that's not what we intended, correct the judicial activism we've seen from the conservative Supreme Court.
And you've been
Can you comment?
urged to by the late Justice Ginsburg. Twice, she sort of begged. She wrote dissents where she said, and she read them from the bench, really signaling her displeasure. And she said, this has gotten to a tipping point, and the only thing that is going to change this is congressional action. And I think she was right. And so I think the only thing that can do this is some change to federal law.
And it's not just progressives who are concerned about this expansion of the Federal Arbitration Act, right? We've heard from attorneys general from 50 states, DC, and territories saying this is a problem. Can you explain that?
Well, so the AGs are very worried because they're getting tons of complaints because these women can't bring actions on their own. They can't bring private litigation. So where do you turn? You turn to the public enforcer because you don't want to go into arbitration and have your claim decided by some arbitrator but never to be heard from again. You want to make change in your workplace forevermore, so you go to the public enforcer. But the problem is, especially in recent years, post-COVID, they don't have the staff for it. They don't have the resources. So we can't rely on the public enforcer to do the work that Congress intended private individuals to do when they enacted Title VII.
Thank you. I yield back.
Thank you.
Mr. Chair.
The gentlelady yields back. Mr. McClintock? Oh, I'm
Mr.
sorry.
Chair. Mr. Chair, I just really quickly wanted to ask, given that one of the witnesses' names was used very, directly, would they have the opportunity to respond?
Yeah, for 30 seconds.
It was Ms. St. John's whose name was referred to. Thank you.
Thank you. When a business saves money in one area, it's going to invest the money somewhere else. I think it's perfectly reasonable to think that if the benefits are abbreviated for employees in one area, they're going to invest in another area on behalf of those employees. Thank you.
Mr. McClintock?
Thank you, Mr. Chairman. First, to be clear, rape, sexual assault are serious, serious crimes, punishable by serious, serious penalties. Is there anything in an arbitration agreement that prevents the perpetrator from being charged and prosecuted under these criminal laws, Ms. Perry?
None whatsoever. They will always have the right of criminal redress in every one of these claims.
Would it ever be possible under our system of justice to write an arbitration clause that would forestall the ability of a prosecutor to bring charges for these serious crimes?
No, it would be legally unenforceable.
Ms. St. John, do you agree?
Yes, absolutely.
The constitutional argument we hear is that the Seventh Amendment guarantees the right of a jury trial in common lawsuits over $20, and that arbitration clauses violate this guarantee. But the Constitution also recognizes the sanctity of contracts. Fact of the matter is, First Amendment guarantees us the freedom of speech, and yet non-disclosure agreements are often common in contracts as well. I think every contract ultimately constrains and limits the rights of both parties. That's why you have a contract. One party gives up money, the other party gives up time. Every condition of a contract requires either one or both of the parties to give up individual rights in order to reach a mutually agreeable outcome. If the net result of the agreement is not beneficial to either party, then the agreement simply doesn't take place. This business of forced arbitration, force requires a gun, and I believe we all can agree a gun is a bad thing to be brought into a voluntary agreement between two parties. But the fact of the matter is, it seems to me that if once we start limiting the freedom of parties to contract with each other, we lose that mutual negotiation that produces an agreement that both sides benefit from. What am I missing here?
For my part, nothing.
Ms. St. John?
I agree with that. These are voluntary agreements.
Let me ask you this. If arbitration agreements are such a bad thing, why would we exempt unions from the provisions of this bill? Either of you have an explanation for that? Neither do I. It seems to me, for my part, thinking, as an employee, I would personally prefer an arbitration clause because, frankly, I can't afford an attorney. I can't afford the enormous costs of going to trial. I wouldn't want to wait years and years with something like that hanging over my head. Now, that's just me. I make that choice when I approach an employer. The employer might prefer the same thing. He might not. If he doesn't, I might ask for something more or simply say, terms aren't acceptable to me, I'll go elsewhere. If the employer says that he agrees, well, then we have an agreement that's mutually beneficial. And I wonder what gives members of Congress the right to tell us that we can't enter such an agreement.
I think you've stated the issue quite eloquently. This is a matter of state and common law. We have been overseeing contracts for years between private parties. The more we get involved at the federal level, the more problematic the trend can become. Again, these are not contracts of adhesion. If they are, they can be challenged in court. And the outsized power, I believe, is most fully exercised during litigation, where a giant corporation like LVMH has multiple millions of dollars available for litigation.
As an employee, that would scare the hell out of me.
It would me as well.
Their legal department with my meager resources.
Absolutely.
There's a provision in there that provides for an opt-out once the dispute is established. What effect does that have on the parties?
I would say, based on prevailing rhetoric, it is probably going to disincentivize someone to pursue arbitration. What we're hearing is that the only solution, the best solution, is going to court. At that point, the balance of power has changed most significantly, and I find that problematic because there are different incentives, different driving factors. One with a low-value claim will definitely want to take it to court. A high-value claim would want to arbitrate. There are so many intersecting interests at that point and so many disparities among the two individuals after a sexual assault or sexual harassment claim have been filed that it makes arbitration impractical, if not impossible.
Thank you.
Gentleman yields back. Ms. Garcia.
Thank you, Mr. Chairman, and I must say that first I want to thank the witnesses for testifying today. I know it takes an incredible amount of courage to share such painful stories and to have to relive the words and bring back some of the memories of every circumstance that you've described. It's, I think a couple of you brought a little tear in my eye right here because it's just so, so painful, and I can see that. As a former judge, you know, I have a very deeply held belief that everybody should have their day in court. Everybody should have their day in court. That is just the essence of justice for all in our country. So we're glad to be able to hear from you today on this bill so that we can act, as others have said, and do justice for all of you. I want to start a little bit for where Ms. Demings left off with Ms. Henry. You know, when she was talking about the culture, it's interesting to me to see that all four of you are from very, very different sectors, different levels of professional work that you do, different environments, but yet it's the same culture. And it's the same kind of situation that happens to women across America. And I must admit that even I, even as a judge, was sexually harassed at the workplace. So it happens to all of us. And I know it's hard to relive the moments, but Ms. Henry, can you just tell me how you really felt? I mean, I know I remember how I felt. How did you feel when your employer even went to your home? Did you fear for your life?
I really didn't know what to anticipate from the whole thing. It got to the point where it was out of control. Yes, I did fear there could be more. As the more angry he became, the more I turned him down and asked him to stop. I was worried for my safety. I was also, I'm sorry, this.
Take your time, take your time.
I felt ashamed. I felt, I'm a working woman. I've been in the workforce for a very long time. I didn't deserve this. I didn't deserve to be treated this way. I did feel like I was a strong woman, but when someone treats you that way, they beat you down, and you feel like you have nobody to talk to. So I was afraid to even say anything, but it got to the point where maybe I was fearing. That's why I had finally, tried to get some help.
Right. And how about you, Ms. Newton?
I had
You
similar
share-
feelings, yes, about how I felt. I was just demeaned. Sorry, I'm having trouble with my mask, but I felt extremely demeaned and humiliated. I felt that I was being made an example of, that I was being used as a poster child of, don't come to us with this type of thing, otherwise we will name you in an email by the CEO. We will, sit you in the side and sit the harasser up front. Similar to what Laura said, I felt very isolated. I think I've even written to friends, I feel beaten down. I said that.
Thank you. What about you, Ms. Dushku? And it's surprising that even in your industry that people watched what your predator was doing and nobody did anything.
Yes, I felt unprotected, and I felt angry. I felt confused, as all the other women have described. It's like a suffocating feeling, because just that, as human beings, to have our voice and be able to speak out when someone, disrespects you, and as a grown woman, as a adult, as a human being, demeaning, suffocating. I just came home every night and, could tell my husband. And it was also just so shocking that in this day and age, as you said, as so many have spoken about, the culture was accepting of that. And while I don't blame some of the individuals, because they too reported to their bosses and didn't want to lose their jobs, it starts from the head. And when you have someone who's in such a high position of power and they're the boss, who confronts the boss if they don't expect in some sense that they could lose their job? And so when these arbitration clauses protect the bosses, there's no justice for any of the employees of the culture.
Thank you. And I know we've heard a lot from the last witness, and I know that you've talked about fear, and I think you said earlier that you didn't go to the police because you were in Brazil, right?
Yes, that's right.
And that you have to have a level of trust to be able to sit down and talk to law enforcement about this. I know that that's true for many rape victims.
Absolutely, and you need to speak the same language as them, and so there were a lot of reasons why I didn't go to the police.
Well, thank you. And again, I see that my time is running short, but I just wanted to ask, well, I wanted to ask all of you, but my time is short, so I'll start with you. When did you,
Yeah.
I'm sorry?
Yeah, gentlelady's time expired.
My time is up. Well,
minute
I yield back.
17 seconds ago. Mr. Tiffany.
Thank you. Thank you, Mr. Chairman. Say, Mr. Chairman, I just arrived at this hearing. Is it correct that the collective bargaining provision excluding unions has been struck from this bill?
Yes.
So that provision in the bill in regards to collective bargaining agreements has been struck. Is that?
Yeah, it's going to be an amendment in nature of a substitute doing that.
Okay. Okay. Thank you very much, Mr. Chairman. Ms. Perry, first of all, before we start here, I want to thank all the witnesses for being here today in what is, I'm sure, not an easy thing to come before a Committee of the United States Congress, and thank you for attending today and giving your testimony. Ms. Perry, Representative McClintock posed a question to you in regards to arbitration, and I got the impression that there was more that could be added. Do you wish to add on to your testimony that you were giving in regards to Mr. McClintock's question in regards to, I think you used the phrase arbitration impossible?
Ex post, after an offense has occurred, the interest of the parties has changed significantly. One is put in a status of being a victim and one is a perpetrator. At that point, making arbitration a viable opportunity for the individual claimants is next to impossible. Getting to that agreement itself is going to be incentivized differently, particularly so by employers who at that point will most certainly want to keep it out of the public eye, and depending on the value of the claim, will figure it's faster and cheaper to go through arbitration in the first place. So an ex post provision on something like this is unlikely to have any meaningful effect.
Do I hear in this process that you're talking about this actually could put the employer in a stronger position?
Yes, it could. Absolutely.
Significantly stronger?
Yes.
Would this process be better if the process was allowed to be public record so everyone was on notice of the offenses instead of striking arbitration altogether?
That's a very accurate assessment of my position on this, precisely if we are going to get involved in longstanding precedent and federal law that has been routinely upheld. Let's do it to the most narrow extent possible and make sure that the entire premise for today's hearing, which is shielding bad actors, is removed altogether.
Thank you, and I will yield back, Mr. Chairman.
The gentleman yields back. Ms. McBeth.
Thank you so much, Chairman Nadler, and good afternoon to all of our witnesses today. Thank you so very much for being here. And just thank you for sharing your experiences surviving sexual violence and harassment in the workplace. And I have read each of your testimonies, and I know this is not at all easy for any of you. So I praise you all for your courage and your strength. And I also want to thank our experts who are here today as you continue just to shine more light on these issues. And I know that one of the reasons it's so consequential that you're here before us sharing your experiences is because some of you are subject to arbitration clauses that were forced really upon you when you entered employment. And I can only imagine that when you first began to work for your company, you were filled with the excitement and all the eagerness, for your new journey that laid before you. And you could not have imagined, I'm sure, that you were also signing up to be silenced and suppressed at the same time. No one should ever have to experience violence or harassment when they're just simply trying to put food on their family's table or doing the work that they love. And if they are so cruelly subjected to that, then they should not then be forced to arbitrate their claims and coerced into silence. And the secretive and the confidential nature of arbitration, it always just kind of allows companies to prioritize protecting their own image instead of seeking justice and really seeking truth. And this has allowed, as we're hearing today, countless stories of women and men's trauma that's been hushed and hidden. And I just want to say, but because of your strength, those of you that are before us today, in particular, all of you women that are sharing your stories, I hope that, future survivors will not have to suffer in silence anymore. And I'm so grateful for your being here today. And my questions are really actually for each of the survivors. And I preface them by saying, please take your time, the time that you need when answering them. But also, I'd really like to be able to hear from all of you. So if you can, just very succinctly, how have your experiences enduring these horrific sexual violence and also arbitration and retaliation affected your physical and your mental health? Ms. Newton, I'd like to start with you.
Thank you. Congresswoman. For me, my physical health has been jeopardized constantly. I was hospitalized twice last year. I have been diagnosed with PTSD. I have now a team of medical advisors because of all of the consequences I've suffered in having to deal with the amount of stress that this causes me. And I had to take medical leave earlier this year. So it's a constant source of damage to my emotional and mental and physical health as well.
Anyone else like to respond?
I mean, I can speak to my experience just as far as, you know, I was coming into a time in my life where I was getting married. I had my first child. I just had my second child 3 months ago. And every single time I have to relive this experience and retell this experience, the re-traumatization is very real. My situation was not, you know, there was not a physical assault, but the words leave me to this day with a feeling of hands on my throat. Like you feel like you can't breathe. It's affects your relationships with your colleagues and your family. It's so isolating. The isolation is just maybe one of the most horrendous parts, because I think we heal through telling our stories, we heal through connecting with others, and the inability to do that, it just leaves you in this isolated, lonely place. The shame that people have talked about is very real. You're reshamed by you know, your harassers through the process. I was horribly reshamed while in the process leading up to this by my employer and my harassers, and I want to leave the others time as well, but that's just, those are some examples.
Anyone else like to respond? If not, my time is up.
Just to respond quickly, I recovered very quickly from my physical injuries, but I have PTSD, and that affects my life every day. And in addition, the stress of being in ongoing litigation and knowing that every time I talk to my parents, Chishti is an ongoing presence in our lives and costing us money and invading our time together. My relationships with my parents will never be the same, and my relationships with other people, my trust is just shattered.
Thank you so very much, each of you, and my time is up.
Gentlelady yields back. Ms. Sparts.
Thank you, Mr. Chairman. I have a little bit different question. Maybe, Ms. Perry, I'll ask you. And it's unfortunate and it's sad that things like that happen. And it's, you know, a lot of brave women willing to step up and have that conversation. So I think it's good to have conversation. But there are also situations where some women might be not feeling comfortable to go in the court of law, get an attorney, you know, and it's got much longer process, much more public process. And I can see some women would have a valid concern if that, you know, arbitration process is not available. You know, they might actually just either live with it or leave, you know, the job. You know, and if we, you know, if I look at this bill, if I write like that with very broad definitions too, I mean, it could have some entrepreneurship with some attorneys, and in most cases I've seen, I'm nothing against trial lawyers, but a lot of cases I've seen, they the only one ended up with the money, not actually victims. But it's also, you know, companies wouldn't even offer that option, which is actually could be valuable option for some of the, you know, women. So my question would be for you, if you would look at arbitration process, and I'm not an attorney, so I wanted to see, is there something within the process, you know, that could be improved? And also, if this, arbitration company is not doing proper due diligence. What is the recourse? What recourse is available? Or maybe the recourse could be available from that standpoint. If something's really doing something wrong and is not really taking seriously the case, or biased, or is not doing a good job. So if you can just maybe list a few of the things that maybe could be improved within the process.
There are a number of remedies that are available to claimants here. One of them is a claim for material breach of the arbitration clause itself. One of them is vacation of an arbitration award when it's determined that the parties were in outsized influences of power that contain terms that solely benefit an employer. The Fourth Circuit ruled that in a decision from 1999. It's been so held by the other federal circuits as well. The FAA guarantees neutrality in the arbitrators, and if there is any evidence of impartiality, that too can be the vacation of an award. There are EEOC claims that can be brought simultaneously, and the Supreme Court has universally held we want to make sure individuals don't just go through arbitration, but they go through the EEOC because we want to make sure that these claims are a federal recordation of what's transpiring behind closed doors. So there are multiple avenues here that can still be pursued. There is nothing in the FAA that prevents individuals from going to appropriate law enforcement officers, filing an EEOC claim, bringing a claim for adhesive contracts, contracts that are outweighed, outbalanced. So there are options through the FAA that allow particular claimants like those here. And I want to stress, this is a uniquely female issue. The EEOC statistics from last year, only 16% of 6,500 claimants were men. This is a culture specifically, relatedly, dealing with female harassment. Women bear the brunt of sexual harassment. I'm a former plaintiff's lawyer representing women in claims against major corporations. I've also seen how outgunned they are when litigation is pursued as an option. And universally, they end up settling because they cannot carry the financial burden. So there are safeguards in place.
Would the gentlelady yield?
Just a second. So if you would look at everything what is there, if there is something that could be improved, because you've been on that side, and I'm just saying, I'm not an attorney, I try to understand because it's a point and valid issue. If there is something that could be improved within legal framework, that it is the system is, give that option, but still have a transparency that needed, is there some things that you could state a few things, and then I'll yield.
Yes, confidentiality and the use of non-disclosure agreements. If we're going to carve out these exceptions for sexual harassment and sexual abuse claims, we need to copy them alongside with NDA and confidentiality provisions so that all of the discussions we're having about transparency and perpetuation of bad actors can be solved. If that is truly the issue, let's disclose everything. Let's modify the FAA only to the extent that bad actors in these particular claims can ultimately be brought to the light.
Okay, thank you, and I yield to Chairman.
I thank the gentlelady for yielding. I just want to point out that we have nothing against arbitration. If the woman in the case chooses arbitration, that's her choice. The point of the bill is that she should have that choice rather than be bound by an arbitration clause that was
I reclaim my time. I'm just saying that employers will have no incentive to propose this in agreements. They will just say completely take it out because there is no reason for them even to do that. That's my concern is if that legislation passes, they don't have to, they can't be, they don't have to propose it at all in these cases.
Further yield?
My time has expired.
I'd ask unanimous consent that the gentlelady be given one additional minute.
Without objection, and I thank the gentleman, and I thank the gentlelady. But the point is, she should be able to choose arbitration. If someone has a dispute with the company, and she and the company both prefer arbitration, fine. The point of the bill is that very often in employment contracts, which you have to sign if you want to get a job, there's a mandatory arbitration clause, which means you have no choice And that's what we want to solve here.
Well, I reclaim it. Just quickly, but I understand you. I'm just saying that will give companies not to have even an option to offer them, because they have no incentive then to offer arbitration as an option at all if you have them to put in the, when it has to be one, both of that. That's what that my concern is, that they will not even have it. And I'm, as an employee, going to come to this big company and say, I want it. They say, no, too bad. They don't have to, right? I don't have that negotiation power. So if we want to resolve it, maybe we should look more in transparency. But I understand your point, so I yield back. My time is expired.
The gentlelady's time has expired. Mr. Neguse.
Thank you, Mr. Chairman. And I want to say thank you for hosting this hearing today. And I certainly am supportive of the underlying legislation. And I want to say thank you to each of the witnesses. Thank you so much for appearing today and for your very brave testimony. Professor Gillis, I'd like to point you to a 2016 letter released by the civil rights organization, the Leadership Conference on Civil and Human Rights. And in that letter, the organization says, quote, "Forced arbitration does not allow public scrutiny of alleged discrimination, nor does it allow for the creation of judicial opinions that help develop the law and provide further guidance on emerging trends. As a result, landmark civil rights laws, such as those protecting employees from race, gender, and age discrimination, have been rendered meaningless," end quote. I wonder if you could opine as to whether or not you agree with that assertion, and if so, perhaps elaborate on how protections against sexual harassment are sidelined by arbitration in terms of the conference's position.
Thank you, Congressman, for the question. I totally agree with the letter. I feel like I've written words like that in articles about the impact of forced arbitration. The reality is not that difficult to discern if claims are being shunted into a hermetically sealed, siloed, private regime where corporations write the rules, employees and consumers can't bring collective claims. There's no written decision, and despite some of the discussion, I won't call it out by name, but despite some of the discussion about how easy it is to go to court and have your arbitration clause deemed unenforceable, that's actually not the case. We've spent the last decade litigating all of these arbitration clauses in court after court. Dutifully following the Supreme Court has upheld arbitration clauses 9 times out of 10. So I think the problems are severe, and I think you're right to point out that they're particularly severe when we think about the most vulnerable groups in our society, minorities, women, low-wage workers, people who often lack political voice and for whom collective litigation is probably the only way that they're going to be able to resolve their disputes. I also just want to take a moment, although the representative is left, to just note that the discussion that was just being had is a little hard to sort of keep on the record. Post-dispute arbitration is fine. And the truth is, if employers don't have an incentive to offer it after the dispute has arisen, then I don't understand why there's an incentive beforehand that's not completely unfair and illegal, right? It's very possible, as the chairman said, that an employee and an employer could decide that they just want to resolve the dispute in arbitration once the dispute has arisen. The incentives are still there if you believe them, which is that maybe it's faster, maybe it's cheaper, and maybe the secrecy or the privacy is of benefit to both parties. I don't understand the argument that an employer suddenly won't want to offer that as an option, and I think that that's wrong.
Well, I certainly share your confusion on that point. I wasn't going to address it, but I'm glad that you did and that the chairman did as well. And I couldn't agree with you more, and not to belabor the point, but I think your summation of the various reasons why arbitration can be so flawed in terms of corporations writing the rules and victims and employees and consumers being unable to pursue collective claims, and ultimately a process devoid of any transparency is all the more reason for us to move forward with the underlying legislation. So again, I thank you for your testimony, and I thank all of the witnesses for their testimony today. And with that, I will yield back to the chairman. Yield back the balance of my time.
Gentleman yields back. Mr. Bentz.
Thank you, Mr. Chair, and thank you to the witnesses for their strength and courage and certainly patience for being here today. I'm tempted to talk about one of the remarks that was made about the jury system being, quote, the essence of justice for all. I'm a trial lawyer, not a very good one, but tried a lot of cases. And I would just suggest there's a lot of room for improvement when it comes to jury trials, not to mention some of the things that give them their merit, which is the crucible of cross-examination. And I would just suggest that many people that have gone through the horror, terror that you folks have would want to avoid that. You're here today, and I'm very proud of you for being here. I have a question for Ms. Perry, and it goes to what should be the default position in these contracts? If not arbitration, then what? Because as we know, at least I think that's what I understand from the research I've done in anticipation of this hearing, is that arbitration has evolved as a device to limit risk and to make more certain the future of the activities of a business or others. And so if we're not going to have arbitration as the default device, what would it be?
That's an excellent question. I think the only other option would be litigation, and understanding what we're up against in terms of the costs and the delays associated with federal litigation. You are looking at very much justice delayed in these particular circumstances. What we're doing is we are forcing everything through an expensive, protracted process in which the imbalance of powers between individuals and their employers is significantly intensified. I would not want to face a multinational corporation bringing suit against me for attorney's fees, because if I had had the option to pursue it another way with a neutral arbitrator in tripartite litigation or arbitration, which is allowed under the FAA, I would certainly want to do that. I would want to appoint my own arbitrator, the company would appoint its own, and there would be a neutral umpire arbitrator, and that's really, I think, the ideal way to go forward on these cases.
One of the reasons the arbitration device has been embraced, if you will, by business and others is to avoid the runaway jury. And if you look at one of the problems that goes with juries, is there's that.
Yes.
And the old concept that you're going to get a balanced result isn't necessarily always true. And so the challenge, I suppose, is that if this bill passes, isn't it correct to say that we will see the cost of such a result spread about among all of us as we see corporations resorting to what would then be the default, that is litigation. Is that a correct? And I'm not, by the way, I'm not trying to demean or belittle or suggest that anybody shouldn't receive proper recompense for whatever bad things have happened. They should. So we're really debating here how best to do it. And I think that was what Ms. Sparks was trying to get at. Can we improve the arbitration device, or should we chuck it in the dumpster? Your answer.
I think we can improve it. I think those confidentiality provisions are front and center in this debate that's going on right now. If indeed confidentiality is perpetuating Me Too, then we need to make sure that we eliminate those. But I'm not even hearing that that is a suitable suggestion. Professor Giles said specifically she still doesn't like that opportunity. So is it in fact that these sex harassment claims are subject to confidentiality provisions? And if we make sure that they are not implicated, everything will be fine, or is it a piecemeal slice and dice of the FAA?
Correct. That would appear to be a good summary of where we are. Thank you so much. I yield back.
Could a gentleman yield?
Yes, I will.
Thank you. Following up on that, we have the question of non-disclosures at the end of the process. Because you've looked at this and studied it so much, if at some future time we're dealing with reform that is not this bill, but something going forward, how would you deal with the fact that in a normal litigation situation, the plaintiff gets the benefit of basically the whole company knowing about the allegation, and thus people often come forward. In an arbitration, normally it doesn't become as public, and therefore you may be dealing piecemeal with different litigants over time. What would be the best way for us to consider parsing that to get justice for someone so that they not be alone as though they're the only one, if in fact there are multiples within the company, as there often are?
Well, I'd naturally suggest class actions, but we know how the Supreme Court has ruled on that, and they say under the FAA, class actions are not.
I was thinking more of how do we ensure that someone who feels they've been wronged can in fact make it public enough in advance, because non-disclosures sometimes would create a situation in which it wouldn't. And I wonder that, because I'm hoping that we're all taking this legislation seriously, even if we oppose its current form.
Yes, again, at the risk of repeating myself, I go back to the privacy concerns and knowing that 5 states have successfully passed legislation to that effect to make sure that these contracts, just like any other contract, make sure there is no coercion, there is no privacy, that these will be as public as a matter of public litigation. I think that's a suitable alternative to what we have now.
Thank you. Thanks, gentlemen, for yielding.
The gentleman yields back. Mr. Stanton.
Thank you very much, Mr. Chairman, to our panel of witnesses. My words cannot possibly express how deeply meaningful and impactful your testimony has been today. But I must begin by saying that I have a profound appreciation and sincere respect for each of you for sharing your stories, which are intensely personal, and for standing with moxie to expose behavior that is too often hidden from public view. Forced arbitration agreements are a piece of the systems and procedures designed to silence critical voices, perpetuate abuse, and enable predators to hold on to their positions of power. We are taught that light exposes truth, and it is clear to me that justice is rarely done in secret. So, I am pleased that this committee and this Congress have made it a priority to address this issue in a bipartisan fashion to ensure that there are additional pathways to justice for those who experience sexual violence, harassment, and retaliation in the workplace. I have a few questions for Ms. Newton. Ms. Newton, you described the CEO of Louis Vuitton sending an email to the entire company a day after your complaint in court. How did that make you feel?
It felt awful, and let me just briefly say I work for the holding company LVMH, their American affiliate, but it felt humiliating. I was sitting at my desk when that email was sent, working. I was already afraid to have filed a complaint against my employer while working, sitting at my desk, going through my emails, doing my work, and I see it popped up, and the whole email was basically about my case, totally discredited me. As an attorney, I pride myself on my credibility, and it's what we hold as our value as attorneys, and that was completely destroyed in a second.
In your time at Louis Vuitton and the holding company, did the CEO ever issue this type of company-wide email?
Never, nothing like it. Not attacking an employee about reporting sexual harassment or anything near it.
Is it your impression at the time that the email was in retaliation for you filing the sexual harassment complaint?
Definitely. The extent that it went to, it wasn't just a bland email. It was several paragraphs long, several sentences long, and the extent it went to mischaracterize what had happened and the nature of my complaint was definitely done with an intent to not only silence me, but to send a message to other people. We will crucify you if you report and if you do things like this.
Was it your impression this was damage control by the company?
Yes.
If the CEO ever thought his behavior would be made public, do you believe he would have taken this action?
No, I think every single move they made was because they knew that eventually, as they succeeded to do, they would get this into a closed-door proceeding.
Ms. Newton, you were asked to apologize to your harasser. Is that correct?
Unfortunately, yes.
And did they explain why you had to do that?
They said that the stalker, he couldn't sleep, he couldn't eat because I had confronted him about the harassment, and he needed to be able to do his job, and therefore I should apologize to him.
Has your standing at Louis Vuitton and the holding company been impacted since reporting your harassment?
Since reporting it, I've received negative reviews. My annual salary increase went down, my bonus went down. I've probably been passed over for promotions to subsidiary companies. My career has been stalled and has just been put on ice, really, and potentially damaged in the future.
If employees were able to pursue traditional lawsuit before a jury of one's peers, do you believe the company would be forced to take sexual harassment allegations seriously?
100%. I think the fact that they know that eventually this will be behind a closed door completely colors every single action that they take in responding to it. They know this will never see sunlight. Therefore, we can do whatever we want.
Knowing what happened to you at Louis Vuitton and the holding company, and the company's response, do you believe that other victims at the company will come forward to report sexual harassment or sexual violence in the workplace?
Sorry, just so I understand your question correctly, are you saying other employees at LVMH will come forward after they... Sorry, could you just rephrase? I'm sorry.
No problem. I apologize. Okay. Knowing what happened to you and the knowledge of what happened to you,
I see.
What's going to be the impact on other employees who may have, sadly, similar type claims?
Oh, yeah, I think this is going to stop them from ever coming forward. This type of crucifixion, making a public shame out of me, is nothing that anyone would want to go through. It's just devastating and humiliating and degrading. And I think they were showing other people, if you do this, you will go down like she did.
Your courage is really amazing. Thank you for your testimony today. I yield back.
Gentlelady yields back. Ms. Dean.
Thank you, Mr. Chairman. It's been widely reported, and every person to a person has shown that there is a culture in many workplaces, sadly. 1 in 4 women have experienced sexual harassment at work. 85% of women report experiencing unwanted sexual behaviors in the workplace. We've spoken in this committee of the legal black hole that is forced arbitration. Think of the words themselves, forced arbitration. It's paradoxical. It's self-evident that there's a problem with this process. It protects companies. It hides predators in plain sight. Your stories have revealed that. I want to use my time to hear a little more from you. I was debating whether to call you victims or survivors. I've decided to call you 4 women of strength. I thank you for your immense courage to share your stories. I'm humbled by your strength. We, here in Congress, need to be humbled by your strength. We are obligated to do better. Ms. Henry, may I start with you? Something you said, many things you said in your testimony struck me. You shared with us that you, quote, gathered all of your courage that you could stomach and filed a lawsuit. I think people don't have any clue what that moment is like, let alone the moment when the door got slammed on you when you learned about the forced arbitration. What was that moment like? What was the challenge there to come forward and say, I've got to sue over this?
At that point, I was feeling defeated, and I don't like to feel defeated, especially over something like this. I thought, I have to do this. I have to do this for other women. I have to do it for myself. I have to, set example for my son, and it's very important to me just to show my courage and do this.
Well, you've done that.
Thanks.
A woman of strength. How did you feel when you read the motion to dismiss your lawsuit and learned of the forced arbitration clause buried in your paperwork?
I was kind of just taken back because I had no idea what it was. I had no idea that something even existed. I thought if in the workplace or even just in society in general, that if someone does something against you that is wrong illegally or however the case may be, I just thought I would have a right to not let this happen to me or anybody else in the future. I was just taken back. I still am. This is very, I just can't believe that people are allowed to just disrespect other human beings.
In fact, you said they stole my right to a jury trial. And your instinct is correct. As an American citizen, you have a right. Mm-hmm. A right was taken from you. To the lawyers, did you feel the same way? Did you feel as though your rights were stripped away from you? Not just the assaults, the attacks, the rape, but did you feel your constitutional right was taken from you, Ms. Newman?
Definitely. In law school, constitutional law was my favorite course. And my parents are immigrants here, and one of the things I think, coming from an immigrant family, that people admire all over the world is our judicial system. I remember my mom saying to me when we were young, in America, you have this right. If something goes wrong, you have your right to a day in court. So I felt like that was totally taken away from me, and no one even knew.
You, armed with a law degree, had your right taken away from you.
Yes.
Ms. Spotteswood.
Thank you for the question. I just wanted to answer that by addressing something that a lot of people have said here, which is that jury trials are very slow and expensive. And I don't actually know really what they're like because I haven't experienced one, but I can tell you that my arbitration was very slow and very expensive. And the cheapest thing to do, rather than trying to unburden our courts by forcing victims like us into arbitration, would be to just not assault people and harass people in your workplace. And if we had access to jury trials, maybe instead of all of us having to go through this very slow process, people just wouldn't act that way as much anymore.
Thank you, very wise words. And I just want to, my time is up. Let me just quote Ruth Bader Ginsburg in 2018. She said, "How treacherously we have strayed from the principle that arbitration is a matter of consent, not coercion." How far we have strayed. I yield back.
Gentlelady yields back. Mr. Jones.
Thank you, Mr. Chairman. I also want to thank my colleagues, Representative Jayapal and Subcommittee Chair Cicilline, for their leadership in introducing legislation to guarantee survivors of sexual assault and harassment their rights to justice in a court of law. Most importantly, I want to thank all of you courageous survivors described accurately by my colleague as 4 women of strength for testifying before us today. No one should have to experience what you all have experienced. No one in your position or in any position should have their voice silenced. No one should have their access to justice vetoed by their assailants or by powerful corporations that back them. And thanks to you, we are closer than ever before to ensuring that no one is denied justice again. Professor Gillis, thank you for joining us again to shine a light on the injustice of forced arbitration. Throughout the day, we've heard harrowing testimony about the retaliation that so often accompanies sexual assault and harassment. As you know, there are both state and federal laws protecting employees from retaliation for reporting harassment. Yet it is plain that those laws have failed the survivors here with us today. How does forced arbitration make it harder to enforce protections against retaliation?
It makes it harder because we never know about their cases, right? That you've had to subpoena these women to come here and tell you about these cases, because otherwise they would be barred from doing so by the provisions of their contract. So not only does the public at large not learn about these issues, but regulators, policymakers never hear about these issues as well. Companies are able to sweep these matters under the rug and shield serial sexual predators that work in these spaces and often work in quite high places.
Thank you. Are there any claims you've heard today that you would like an additional opportunity to rebut?
Oh, thank you. Yes, so many that I won't have time, although just a few, really, because I think a lot of what's been said has been wrong. So first off, just to reiterate what Tatiana just said, there's been a lot said about how expensive litigation is. Arbitration is expensive too. It's not as though the employer suddenly doesn't show up in arbitration. The employer shows up, and they show up with all of their lawyers and all of their money. So the structural imbalances that exist in the sort of David and Goliath situations that we see, those are going to be true in arbitration and true in litigation. So I think it's wrong, and I think it's misrepresentative to say that only litigation is a problem in terms of cost. The other thing I'd like to just point out is on the freedom of contract argument, which I can only sort of follow. Because the protections in this bill, as I read this bill, are only triggered when a survivor files a lawsuit. So that means that the contract remains, the employment contract is still fully enforceable. The only point is that when a survivor files a lawsuit, the survivor has a choice about whether to go into arbitration, which perhaps she chooses for whatever reason are hers. She's autonomous, she can choose, or to go into litigation. I think some of the rhetoric today has tried to distract us from that reality, but if you read the bill, that's what the bill says, and I think that's what we should be talking about. There's other things that have been said that I think are mischaracterizations, untruths, just distractions, right? This is a pretty easy, I think, question. These women are here to tell us that this system doesn't work for them, they don't want it, and so we ought to change it.
Thank you. I agree. Mr. Chairman, I yield, Madam Chair, I yield back.
Thank you very much. The gentleman yields. And now the gentlewoman from North Carolina, Ms. Ross, is recognized for 5 minutes.
Thank you very much, Madam Chair, and thank you to all the witnesses for being here today. I know it's difficult to talk about this topic, but it is so important, and you are making a difference in the lives of other women. I'm moved by your bravery and that all that you've done in choosing to share your stories with Congress. In the United States, businesses and other institutions too often cover up sexual assault and harassment in order to maintain their reputations, at the risk of your reputation. As we've heard today and previously, forced arbitration is one of the key strategies these businesses and institutions use to silence victims of sexual violence and harassment. As long as forced arbitration remains an option, businesses and institutions will be able to abuse this mechanism to put profits and their reputation over yours and silence survivors of assault and harassment. Our laws should work to curb practices that enable the abuse of individuals like those we've heard from today. As you can hear, there are bells, but that doesn't have anything to do with this hearing. And I'm glad that tomorrow we are going to mark up a bill to do just that. I have a couple questions for Professor Gillis. The first question is, what effect does the low survivor win rate in employment arbitration have on companies' incentives to stop or prevent sexual misconduct?
I think it must have. I don't work for a company, but I think if I were a company and very few women were even going into arbitration, and the very, very brave few who did, who were able to go it alone and hire a lawyer to bring an arbitration, and they still didn't win, I would start to feel like I could do whatever I wanted. And I think that that's probably what we're seeing. Now, I don't know, I'm not invited into the rooms where those sorts of decisions are being made, but I think it's a safe bet that companies are feeling quite brave and brazen in the ways that they could cover up pervasive and systematic sexual assault and harassment and discrimination in the workplace.
And just as a follow-up to that, do you think it has the same effect on predators, on people who commit sexual misconduct and violence against women?
Again, I'm only inferring from the data that we have, but because, let me not infer. I have kids, and when my kids don't get in trouble, they just keep doing the same thing over and over again, right? The idea is that if you don't hold someone accountable, they're just going to believe that the behavior is actually not so bad. And the examples the women here are sort of striking because these were all men in positions of power who retain those positions, in one instance promoted, which indicates that these predators are learning nothing, right? They're getting a slap on the wrist, There's no public accountability. Every company has these sort of, sexual harassment training sessions that I think are probably not well attended and not really processed by the people who need them most. These people are not being taken aside and disciplined, or better yet, fired, right? They're not held accountable for what they've done. So I imagine they too feel that they can do whatever they want.
Thank you. And to our survivors and heroines here, what kind of message do you think this sends to more junior people in the businesses where you've worked, and to other institutions about what kind of behavior will be tolerated? And please pipe up as you wish.
I can start. I think I had in mind those young people when I reported, because it was one thing for me to be going through this. I thought about all the girls that I've mentored over my life, there's other students, and my niece, my friends' children, and just thought about, if a lawyer, an executive at a company, am not able to feel comfortable speaking up about these things, and if I am shot down and attacked for doing that, what will they be able to do? So I think that what these companies do is meant to silence people and make them not complain and make them keep quiet and just allow the harassment to continue.
Thank you so much, and I yield back.
The gentlelady yields. The chair now recognizes the gentlelady from the great city of St. Louis, Missouri, Representative Bush.
St. Louis, and I thank you to the chairman for convening this hearing, and thank you as well. I want to sincerely thank each of our witnesses this day. I want you to know that strength is not only moving, it is also saving lives. The failures and accountability for the misconduct and abuse you have endured are tantamount to policy violence, because this body has a responsibility to legislate safety and care for in your workplaces. Like you, I am a survivor. I understand the trauma you must relive in sharing your story. I'm proud of my colleagues for standing firm and demanding that these insidious arbitrary clauses are prohibited. But I am also aware of the lasting harms of the abuse you have been through. You should have never had to decide between paying bills and speaking the truth. You should have never had to fear retaliation for saying what happened. You should have never had to worry about the impacts of unwanted harassment on personal lives. Know that our job as members of Congress see you and stand with you is to build a society where what you endured never happens again to another person. Professor Gillis, how do the use of arbitration clauses in a workplace prevent a company from establishing procedures to fully investigate and meaningfully address reports of sexual harassment?
Thank you for the question. So I think that what happens when an employee complains about sexual harassment on the job and starts an arbitration, and again, those are rare situations, but let's talk about those unicorn situations. The employer becomes aware that there's a problem. They're participating in the arbitration. But then employee two comes forward sometime later and is complaining about the same sorts of pervasive structural problems in the workplace. And at that point, and maybe it takes still employee 3 or employee 4, but at some point, one would imagine that an employer who is hearing these stories, understanding the dynamics of the office, would come to understand we have a problem and we need to do something about the problem. But I think the reality is that employers are forcing these issues into arbitration so that they don't have to be accountable, so they don't have to change policies, so that they can just do things as they've always done them, business as usual. Because there's nothing that the arbitrator can do that can force an employer to take on any systemic changes in the workplace. So I think these provisions really do stop or halt or prevent any efforts to make the workplace safe for all people.
Yes, thank you. And with that, we understand that is why these sexual harassment allegations need to be in the public sphere. Thank you. Henry and Dushku, both of you were sexually harassed or violated by a man who he could get away with anything. This behaves not just occur in a vacuum, nor does it occur overnight, as colleagues have mentioned. You haven't been allowed to tell your stories before today. I'd like to use my time to each of you the opportunity to share what it means to you personally to finally chance to speak publicly about such personal and traumatic experiences, including the retaliation you suffered because of the arbitrary clause in your employment contract. And let me say before you start, I'm truly sorry for what you've had to endure. Ms. Henry.
I just want to make sure I understand the question. Break it up just a little bit.
Oh, I'm sorry. Just being able to publicly share about your personal experience, because today is the first day you've been able to talk about it. So is there anything that you would like to say that you would just share publicly, since this is your first time sharing your personal traumatic experience?
I just hope at some point that the person that did this to me has to feel as humiliated as I feel, and how ashamed that I felt during this whole process. I am very honored to be here, and I really appreciate having this chance. And hopefully in the future, no one has to endure such horrific acts as we all have sitting here today. So I just hope that he just can feel the pain that I have felt.
Ms. Dushku, would you also?
Yes, thank you. I mean, on the one hand, as Ms. Henry said, it's very liberating. And at the same time, after so many years of being in silence, I have to say it affects me, and I still don't in some ways know that I'm allowed to go on from here and continue speaking without fear of future retaliation, even now. But as others have said, as Ms. Newton said as well, I am proud, and I do feel re-empowered to be able to show my niece and my sons and my 3 beautiful stepdaughters that you don't have to accept when the rules are stacked against you, and you can try to change the rules. And I hope that we can do that here today. And I'm just in awe of all the other women there today, and I hope to know you better. And I know that we can all heal from this, but the healing will come from action to protect us and protect future survivors and victims. Thank you.
Thank you, and it's a job to act. With that, I yield back.
The gentlelady yields. This concludes today's very powerful hearing. I want to thank the witnesses again for sharing your incredible stories, and to express yet again how we are standing with you in this moment and moving forward. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing today is adjourned.